Please be seated. The Royal Commission on Antisemitism and Social Cohesion.
Yes.
Commissioner,
Yes, Ms Phillips.
I call Susan Woodward AM.
Yes. Ms Woodward, will you take an oath or make an affirmation?
An affirmation, thank you, Commissioner.
Thank you.
Do you solemnly and sincerely declare and affirm that the evidence you shall give will be the truth, the whole truth, and nothing but the truth? Please say I do.
I do.
Yes, do take a seat.
Thank you.
Can you please state your full name?
Susan Dorothy Woodward.
You are the Commissioner of the Australian Charities and Not-for-Profits Commission.
Yes, I am.
You've prepared a witness statement dated the 29th of July 2026.
Correct? Yes.
And you've included a table within that statement at paragraph 61. And since preparing your statement, is it right that you've identified some corrections to that table which have been included in a separate document?
Correct. The formatting had gone astray.
And if one replaces the table in your witness statement with that separate document that you've provided, is the statement true and correct to the best of your knowledge and belief?
Yes, it is.
Commissioner, I tender the witness statement and the accompanying table. They have doc IDs sta.0557.0001.0001 for the statement, and the table is acn.799.0001.0012.
Yes. The two documents will be received as exhibits.
You were appointed to the position of the full-time Commissioner of the Australian Charities and Not-for-Profits Commission, which I might refer to as the ACNC, for a 5-year term in December of 2022, is that right?
That's correct.
And prior to your appointment, you'd held senior leadership roles in Justice Connect, a legal assistance charity, and you'd also worked for a long time in various other roles in the not-for-profit sector.
Yes, that's correct.
You have academic qualifications in law, is that right?
Yes.
And you've taught over many years in the areas of corporations law, corporate governance, not-for-profit organisations, both as a lecturer and then as a senior fellow at the University of Melbourne.
That's right.
The ACNC was established and began operating in December of 2012, is that right?
Yes, it is.
And you've described it in your witness statement as a relatively new agency.
In regulated terms, it's still considered fairly new. Possibly we're getting to our teenage years, but certainly we're not as well established as some.
And your role as Commissioner of the ACNC, that's a statutory office that's established pursuant to the Australian Charities and Not-for-Profits Commission Act.
Yes, that's correct.
The statutory objects of that legislation are set out in the Act, and you've extracted these at paragraph 7 of your witness statement. One of those objects is to maintain, protect and enhance public trust and confidence in the Australian not-for-profit sector.
Yes, that's accurate.
And another is to support and sustain a robust, vibrant, independent and innovative Australian not-for-profit sector.
Correct.
And another is to promote the reduction of unnecessary regulatory obligations in that sector.
Yes.
And is it the case that the ACNC was formed after a Productivity Commission report had identified a need for regulatory reform to improve accountability, transparency and public confidence within the not-for-profit sector?
Yes, that was one of many reports. That was the most pivotal one, I think, in spurring the establishment of the ACNC.
And one of the reform proposals that I think you've referred to at paragraph 9 in your witness statement of that Productivity Commission report had been that the Australian government establish a national regulator for the sector with responsibility for determining charitable status, maintaining a public register, providing sector guidance and undertaking regulatory oversight. Is that right?
Yes, that's correct.
And is it your understanding that the ACNC was established broadly to give effect to those recommendations?
Yes, it is.
A key statutory function of the Commissioner of the ACNC from time to time is to register eligible not-for-profit entities as certain types or subtypes of charity. Is that correct?
Yes, it is. It is a voluntary registration process.
And In your statement, you've noted that when we talk about not-for-profits, it doesn't necessarily mean that the entity in question can't or won't make a profit. Can you explain that?
Yes, it can be confusing. All charities must operate on a not-for-profit basis, but not all not-for-profit organisations are eligible to be registered as a charity. And the confusing thing happens with the words not-for-profit. A charity can't operate while it's insolvent. That is not allowed. But it's what happens with the profits that really distinguishes between a charity and, if you like, a business. So the profits, the revenue raised from the organisation have to be used for the charitable purpose.
And in terms of an entity that is a not-for-profit but that might not be eligible to be registered as a charity, I think you've given in your witness statement the example of a community sporting club. And is the reason that that kind of not-for-profit entity won't be able to be registered as a charity because its purpose isn't a charitable purpose of the kind recognised in the charities legislation?
Yes, that's correct.
Now, where entities do meet the legal definition of a charity under the Charities Act, how does registration as a charity with the ACNC affect their ability typically to access Commonwealth tax concessions?
As I said, it is a voluntary system, so you don't have to register, but the incentive to register includes that you must be a registered charity if you want to access Commonwealth taxation and other concessional benefits. So it is a pathway, a requirement, stepping stone, if you like, to that.
And in your witness statement, this is at paragraph 46, you've identified that some of those concessions might include an income tax exemption, GST concessions, fringe benefits tax rebates, and for some charities a fringe benefits tax exemption as well.
That's correct.
And is it right that the particular tax concessions that are available to charities that are registered with the ACNC, something which can depend on the type of charity
Yes.
that an entity is registered as?
That's right. There are certain subtypes that so the tax concessions are administered by the ATO, the Australian Taxation Office, and they'll look at which particular subtype the charity has been registered for, because that will affect what they're eligible for in terms of concessions.
And you've described at paragraph 47 of your witness statement DGR, or deductible gift recipient endorsement, as a highly sought after form of tax concession. Is it your understanding that when an entity is endorsed by the ATO as a deductible gift recipient, donors to the charity can receive a tax deduction for the donations that they make?
That's correct.
And you've identified that DGR endorsement is something that's administered by the ATO and not by the ACNC, is that right?
Yes, that's right.
How do you understand the ACNC's registration of an entity as a particular charitable type or subtype to feed in, as it were, to the ATO's process of endorsement of DGRs?
There are some categories, some subtypes that we would register a charity for that then, in a way, effectively mean that they're almost, subject to the ATO doing their processes, will give them that pathway. The most common one in relation to deductible gift recipient, DGR status, would be a term that's called public benevolent institution. So if we determine that part, so we look at the particulars of the registration application and the activities and purposes, and if they meet that category, that can smooth the path to the tax office. We'll accept that, and then they'll apply their taxation provisions to that.
So your understanding in the case of public benevolent institutions, for example, is that if the ACNC has registered an entity with that charity subtype or type, as a matter of course, ordinarily DGR endorsement by the ATO would follow.
Correct, yes.
And in terms of the broader delineation of functions between yourself as the ACNC Commissioner and the Commissioner of Taxation, or the Australian Tax Office, at a broad level, is it right that the function of the ACNC Commissioner is to determine first whether an entity should be registered as a particular type of charity, and then possibly over time to consider enforcement mechanisms and whether the entity is entitled to retain that registration?
Yes, it is. When you're a registered charity, you also have obligations to provide annual information, so that's a way that that information typically appears on the public register, and that can also support the work conducted by the Australian Taxation Office.
And broadly, when it comes to charities, is it right that the role of the Commissioner of Taxation is to administer the taxation laws to entities based upon their charitable registration status as it's been determined by the ACNC Commissioner?
Yes, that's correct.
At paragraph 11 of your witness statement, you've given some figures of the rise in the total number of charities in Australia over the decade from the 30th of June 2015 to the 30th of June 2025. Can I ask you to comment on that trend as you've identified it?
Yes, the number did, when the ACNC was first established, the number varied a little bit because it was establishing a new register, and there were some that had needed to come off and some that came on, and then for a period of time it was relatively stable at around 60,000. The number in the last few years has risen to over 66,000 charities, primarily because of a new reporting provision that the ATO are administering. So if an organisation wants to be income tax exempt, they may, if they want to be income tax exempt, unless they're a registered charity, they'll have to now report separately to the ATO. And this has meant a lot of organisations that perhaps falsely thought they were entitled to operate as a not-for-profit and didn't need to register as a charity have now realised they do need to register with us. Otherwise, they run the risk of having to pay income tax on any net income that they make. So it has brought forward an increase in the total number of registered charities.
And I think you've given a figure of about 17% in terms of total number of charities as between 2015 to 2025. Does that sound
Yes, over
right?
that decade, when you look back at the figures, it is about a 17% increase.
And I think you've identified in your statement that in the 2024 to 2025 year, perhaps on account of the measures that you've just been describing, there was the highest number of new charity registrations in a single year since ACNC was established.
Yes, that's correct.
Has there been a commensurate increase, to your understanding, in the budget allocation to the ACNC's operations over time to reflect perhaps the growth in the total number of charities that are registered with the agency?
That increases in the last few years. There hasn't been a particular allocation to reflect that. We did receive support from the Australian Taxation Commissioner by way of extra staff to deal with that flow on. So under the ACNC Act, the ATO Commissioner makes staff available to me as the ACNC Commissioner. I direct the staff and have that independence. Recognising there was this flow-on effect, the Tax Commissioner did make some additional staff available to us to support us with some of that workload.
And at paragraph 14 of your statement, you've identified the significant role that charities play within Australia's economy, community life and workforce. And you've given a figure that a report in relation that was published on the 11th of June 2026 identified the generation of $239 billion in revenue. First of all, is that in relation to the 2024 reporting period, so an annual basis?
So what happens is that registered charities need to report to us annually. We call it an annual information statement. And as part of the commitment when the ACNC was established, that we've taken very seriously the responsibility to report back the accumulation of that data to better inform the public about the sector and to show really that the incredible economic significance that the sector has. So that is data from the 2024 reporting period, and as you say, it does identify that amount of money in terms of total revenue.
And over at paragraph 17 of your statement, you've identified the proportion of that $239 billion that's come from government. Can I ask you to comment on that?
Yes, the sector gets its income from a range of sources, and when you look up our register, Commissioner, for any particular charity, it does show where for any particular charity the high level of where their revenue comes from, whether it's from government grants, and that could be grants from local government, state government or federal, or whether it's from donations and bequests, or whether it's income they've generated themselves. And collating that all together, it shows overall that nearly about 48% of the total income for the entire sector, registered charity sector, is from government sources. I think it is just, if you don't indulge me, important to note though that that's not every single charity gets government funding. In fact, the vast majority are small and would not get government funding, but the government is a major contributor, often by contracting charities to provide important services.
And that figure of 118 billion, which is about just less than half of the 239 that you've identified in your statement, is that just government income? Would that factor in, for example, the value of deductions that donors might receive from making donations to DGRs?
No, that is actual government income, typically by way of government contracts or government grants, and it's not just federal government, it would also be the other layers of government.
And can I take you to paragraph 18 of your statement? You've noted there that charities occupy a position of substantial public trust, and you've also drawn attention to the public contributions that are made to charities. How do you see those aspects affecting the sort of governance and regulation that are required in the charities sector?
As you outlined before, a key one of our statutory objects, which is in some respects a North Star, a guiding principle for the way that we operate, is around a role in ensuring public trust and confidence in this sector, particularly because the sector is such a vital sector that relies on public trust in terms of the public donating, in terms of the public volunteering, and also in terms of the government contribution and the funding contribution to the sector. I think it's right that we recognise that the sector is both an economic and social significance, and with that comes, if you like, a corresponding responsibility to honour and comply with basic principles to ensure ongoing public trust and confidence in that sector.
Thank you. I'd like to ask you next about some of the more granular mechanics of how the ACNC Act operates, perhaps starting out by introducing some of the key terms that you've gone through in your witness statement, as well as the constitutional footing of the ACNC Act itself. First of all, at paragraphs 50 and 51 of your statement, you've explained that the ACNC Act uses the term responsible entity. Can you outline at a high level who a responsible entity is and what that refers to?
I'm afraid, Commissioner, the Act is not written in a very user-friendly way, but obviously technically correct. So we have the term in the Act responsible entity, and I think if you just think of that, that's the charity, the registered charity. It also talks about there's registered entity, which is the charity, and then there's responsible entities or responsible people. I would summarise that down to the charity, the registered charity, or the people governing the organisation that are actually on our register as being what we call responsible people, so the people that have been nominated by that charity essentially governing the charity, so the board of directors, the committee of management for an incorporated association.
And I'll come back to this a bit later, but I will just note that at paragraph 52 of your statement, you've identified that the ACNC or the ACNC Commissioner has limited powers in relation to responsible entities, particularly in the circumstances set out in Division 100 of the Act. But I'll bring you back to that.
Okay, thank you.
And then at paragraph 54, you've outlined that the ACNC Act, in terms of its enactment, originally principally relied on particular Commonwealth constitutional powers, including the corporation's power and also the territory's power. In a broad sense, are you able to outline the implications of that constitutional footing, particularly for the ability of the ACNC Commissioner to be given powers to regulate responsible persons?
Yes, the residual powers rest with the states and territories. The states are for charities, and so my understanding, and I'm not a constitutional lawyer, and it's not my job to do that, but at a broad level, the ACNC Act draws on that corporation's power that the Commonwealth has. The territory's power when it comes to our external conduct standards rely on that power, and also for other provisions, the taxation power, it becomes relevant. So the foundation of why it's a voluntary system is that people will be voluntarily registering. Then the taxation power is enlivened because they're registering so they can access those taxation benefits. So that's the grounding for the ACNC Act, noting that the state attorneys would keep residual powers over charitable trusts and assets, for example.
And the next concept that you've introduced in your witness statement is one called a federally regulated entity, or an FRE, to use the acronym. In broad terms, are these entities corporations that the Australian Constitution permits to be regulated under Commonwealth legislation as constitutional corporations, as it were?
Yes, sometimes it again can get a little bit technical and confusing. It is there's a range of things that have to be considered in order to meet the definition in the Act. There's no actual definition in the Act about what is a federally regulated entity, but it draws on that constitutional law concept. It's not as simple that if a charity, registered charity, is a corporation under the Corporations Act, that it meets this test. So it's more about whether it's a trading entity, and a whole range of other factors. So it is quite a technical area.
And are you able to give a high-level example of a charity or a charity structure that might be registered as a charity with the ACNC, but which would not be a federally regulated entity?
Perhaps an example would be, let's take a childcare centre. If it was a childcare centre in the ACT, that is a territory that would enliven, that is one example where it meets the federally regulated entity test very clearly. Another childcare centre just across the border in New South Wales is probably not going to meet that test because they probably don't meet the bar of trading and in trade and commerce, for example.
And of the, I think, 66,000 registered charities that I think you gave the figure for before, does the ACNC have oversight at any given time as to how many of them meet that definition of an FRE or a federally regulated entity?
No, we don't. We can't know at any point in time how many of the 66,000 are federally regulated entities, primarily because it is a point-in-time assessment and it can change. And as I say, it's not a clear-cut line that entirely links to their legal structure.
And then the next term that you've addressed at paragraph 58 of your witness statement is a basic religious charity or a BRC, and you've outlined the criteria for that kind of entity there. Can you give an overview of what the criteria are for an entity to be classed as a basic religious charity?
Yes, they're set out in full in the statement at paragraph 58. There are 6 criteria, and primarily they must be entirely for the subtype of advancing religion, so they can't have an additional subtype, for example, advancing education. They must not be a body corporate, so if they're an incorporated association or a company or incorporated under other legislation, then that will mean they can't meet the test. Except with limited exceptions, they can't have that deductible gift recipient status that we talked about before. They can't be part of a reporting group, which has a particular meaning. There's also a monetary limit if they receive grant funding from an Australian government agency. There's a limit of 100,000 over 2 financial years. So, you know, if they receive quite significant government grant funding, they won't be eligible. And the last requirement is that they, if they're required to participate in the National Redress Scheme for Institutional Child Sexual Abuse, and they've been identified as an entity relevant for that, they can't remain as a basic religious charity.
I'd like to ask you next about the processes for registering and the criteria for registering a charity of the various kinds. At paragraph 24 of your statement, I think you've extracted the various criteria that an entity needs to meet in order to be registered as a charity. So is it right that amongst those are that the charity needs to be a not-for-profit and to have an ABN as well?
Sorry, is it
I might
paragraph
have
24?
It's to the wrong. I think 74.
Sorry, which one did you say? I know it's there, but
74.
74.
On page 19.
Okay, thank you.
Sorry about that.
And sorry, what was the question?
Is it right that you've extracted at this part of your statement the conditions that an entity needs to meet in order to be registered by the ACNC as a charity?
Yes, I have, thank you.
And they include that the entity is a not-for-profit entity and that it has an Australian business number?
Correct.
And you've also identified that one of the conditions for registration is that the entity is in compliance with the governance standards and the external conduct standards.
Yes, just to maybe add a further clarification, in terms of the governance standards, basic religious charities do not have to comply with the governance standards, so that's not applicable to them.
And so that won't be a registration criterion for those kinds of charities, compliance with those standards?
Yes.
And the standards themselves, they're set out in the ACNC's regulations made
Correct.
under the Act?
Yes.
And you've extracted a summary of the governance standards as appearing in the regulations at paragraph 77 of your witness statement. Can I just take up a couple of them with you? Is it right that governance standard 3, which you've referred to at 77.3 of your statement, that requires that charities not act in a way that would, under a Commonwealth, state or territory law, could be dealt with as an indictable offence or a breach of a law that has a civil penalty of carrying 60 penalty units or more?
That's correct.
And so that's a standard that applies to charitable entities or applicants to become charitable entities themselves, not to the representatives or the responsible persons of those entities.
Yes, our entire framework is couched very much on our powers are over the entity, not over the individual people governing that organisation.
And in practice, at the point of registration of an entity or seeking to be registered as a charity, how would the ACNC go about trying to work out whether a charity has committed, say, an indictable offence such as to fall foul of governance standard 3?
We do core searches, so we would look at, for example, whether anyone named in the application was associated with was disqualified on the ASIC register, if anyone was on a sanctioned list, like the DFAT sanctioned list, we do other, desktop searches. Primarily, I just perhaps highlight for context that usually when we're considering an application, if it's a new entity, it can be quite difficult because, of course, they're saying this is what we're going to do, this is our proposed constitution, these are the proposed people. They haven't actually already, done activities in the name of the entity itself. So we also have a risk framework. So if we feel that it comes up on our risk framework that we have some reason to be more concerned, we would do more detailed searching.
And just as a hypothetical, and whether it's at the pre-registration or the post-registration stage, if you had a circumstance where it was known or it became known that a director of a charitable entity had committed an indictable offence, is it right that that wouldn't necessarily cause the charity itself to contravene Governance Standard 3? Is that your understanding?
That's correct. Governance Standard 3 talks about the entity, so the charity must not commit the offence. Some of those indictable offences will apply to an entity, but often it might apply to an individual. So under that governance standard, it's not a sort of given that breach flows through to the charity's breach.
And one might need to look at principles of corporate attribution in terms of corporate governance law and the like to work out the circumstances in which an offence by a director, say, can be attributed to the corporate entity itself.
Correct. Was that person authorised by the charity to make that statement, do that activity, or was it, a volunteer associated with the entity that was doing it perhaps as a bit of a rogue or isolated event?
And can I take you to paragraph 77.4 of your statement, where you've referred to Governance Standard 4. You've said there that under this standard, charities must take reasonable steps to ensure that their responsible persons are suitable to hold those positions and are not disqualified from managing a corporation or barred by the ACNC. Can I just check with you, does the regulation that gives effect to Governance Standard 4 at the moment include any broad tests of suitability for responsible persons of charities?
No, it doesn't. It's just simply the two matters that you mentioned.
And so is it the case that, to your understanding, currently under the regulation giving effect to Governance Standard 4, the reasonable steps that charities must take are limited to ensuring that responsible persons first aren't disqualified from managing a corporation and second have not been disqualified previously by the ACNC itself?
That's the minimum standard that they would need to satisfy. When we work with charities, we often see that they might have broader requirements for screening their directors, but that's what's required under that governance standard, yes.
But by the ACNC's legislation
Correct.
itself. And then Governance Standard 5, is that broadly about the need for an entity to ensure that their responsible persons undertake proper management of the charitable organisation?
Yes, I think this standard can sometimes confuse people because it has a sub-list of all the what you would probably describe as fairly typical director type duties, but the governance standard is again on the charity as an entity, and that goes back to that constitutional limitation you raised earlier. So it's a standard that talks about the charity must take reasonable steps to ensure that its responsible people, its directors, understand and comply with then the list of duties underneath that.
And you mentioned Governance Standard 6 earlier, which deals with obligations of entities identified as having been involved in institutional child sex abuse.
And who should be members of the National Redress Scheme, correct?
Another condition of registration which you've identified is compliance with external conduct standards, and you've extracted or summarised these at paragraph 78 of your statement. Is it right that those external conduct standards apply to all charities, including basic religious charities?
That's correct. To enliven the external conduct standards, a charity, including a basic religious charity, would be conducting activities or sending funds overseas.
And broadly, is it the case that those external conduct standards relate to activities that take place outside of Australia or that have some connection with activities outside of Australia?
Exactly.
Another condition for registration of a charity is the one that you've referred to at paragraph 74.4 of your witness statement, that an entity is not covered by a decision in writing made by an Australian government agency, including a judicial officer, under an Australian law that provides for entities to be characterised on the basis of them engaging in or supporting terrorist or other criminal activities. What steps does the ACNC take to try and identify the existence of any such decision, and what form might such decisions take?
We would always check the sanctioned list, so the sanctioned list, I think it's by DFAT, about whether either the entity itself is sanctioned or any individual that might be connected with, in the case of a registration application, the proposed registered charity.
And is the idea there that there needs to be an existing decision in place in relation to an entity that the ACNC goes and seeks to identify?
That's correct, yes.
And where the statutory requirements for an entity to be registered as a charity are satisfied, do you or the Commissioner of the ACNC from time to time have any residual discretion to refuse registration?
No, if they meet the eligibility criteria, they must be registered.
And so at present, just to synthesise the effect of all of that, is it right that it wouldn't be a bar of itself to registration of a charity that its responsible person has been alleged or has been found to have engaged in the past in criminal activities?
Broadly speaking, that's correct.
And is it also the case that at present it wouldn't be a bar to registration that a responsible person has been alleged or has been found in the past to have engaged in a breach of the Racial Discrimination Act?
Yes, unless there was a standard met that on registration it was in some way associated with the charity not having a charitable purpose, or that we could establish that the charity had also not met the governance standard.
I want to ask you next about some of the enforcement functions in respect to charities after they've been registered. At paragraph 61 of your statement, you explain that the Commissioner's powers and functions can vary depending on the type of the registered charity. And just taking up the question of revocation of registration, as a broad proposition, is it right that the ACNC Commissioner is empowered to revoke the registration of all charities?
Yes, that's correct.
But that the grounds on which that power might be exercised can differ as between charities with different statuses?
It can differ primarily on not their legal structure. The framework is not about particular legal structures, but if the charity meets the standard of a basic religious charity, then we wouldn't be able to revoke on the basis of a breach of the governance standards.
And in broad terms, where a ground has been established for a charity's registration to potentially be revoked, is it right that typically revocation won't be automatic, but there'll be a series of considerations that will be taken into account in determining what to do?
Yes, and that's for the reason that obviously if we revoke a charity, we are also, there are under the Act set criteria that I must consider as Commissioner before I exercise that power, and those considerations really go in some extent to acknowledging that a charity is providing services, and it's not quite the same as stopping an organisation because they haven't paid their tax, for example. It's a broader range of considerations.
And you've identified that sometimes when, say, compliance concerns are raised about charities, the ACNC or yourself as Commissioner may determined not to exercise any formal power, but, for example, to engage with the charity in a voluntary fashion, to administer educational guidance and the like.
Yes, and that's an express object in the Act, as an express requirement on me to consider, can we make sure that the charity goes back into compliance by giving them that education and support. So that might be the starting point. Obviously you don't, doesn't mean you don't sort of jump further up the regulatory pyramid of enforcement powers if there's something very serious and you're talking about criminal action, but in the vast majority of organisations we would look to see whether we could support them with education first.
And you've helpfully provided a table that distinguishes between the formal legislative powers that are available with respect to different types of charities. Can I take you to that table, please? It has doc ID ACN.799.001.0012. It's the supplement to your statement. The first page of that document outlines the various, the nature of the powers of the Commissioner to revoke the registration of a registered entity.
Yes.
And can I ask you about the first row? Is it right, and do we take from this table that the Commissioner from time to time has a power to revoke the registration of all types of registered charities on the basis that the charity is or was not entitled to registration in the first place?
That's correct, yes.
And then going to the second row, do we take from that that the Commissioner also is empowered to revoke the registration of all kinds of registered charities where the Commissioner believes the registered charity, in connection with its application for registration, provided information that was false or misleading in a material particular?
Yes, correct.
And in terms of the application documents that are currently required, at the moment, does an entity seeking registration as a charity with the ACNC need to disclose anything about the criminal history of its responsible persons?
No.
Does it need to disclose anything about the history of any determined contraventions of the Racial Discrimination Act on the part of responsible persons?
No, I don't think there's a positive duty to disclose that.
And then in the third row of the table, there's a general revocation power where the Commissioner believes that a charity has contravened a provision of the ACNC Act. That one applies across the board.
Yes, it does.
And the fourth row refers to revocation for non-compliance with governance standards, and you've indicated that already, I think, that a BRC or a basic religious charity isn't bound by governance standards under the legislation, so non-compliance with the governance standard is not a ground for revocation of
Yes, the only exception there would be Governance Standard 6, which is having to be a member of the National Redress Scheme.
The next row refers to external conduct standards, and I think you've indicated already they apply to overseas activities for all charities. And at paragraph 86 of your statement, you've commented on some limitations that might arise in the ACNC Commissioner's revocation powers. And what you say there is that revocation, though a serious regulatory intervention, may not fully address misconduct or wrongdoing and or be a blunt tool. Can I ask you to expand on what you mean there about revocation potentially being a blunt tool?
Sorry, which paragraph was that? I know the heading, but...
I think it was paragraph 86.
86, thank you.
Page 23 of your statement.
I felt like there was another paragraph that had the heading blunt tool, but anyway, sorry, the question was...
if I can take you to paragraph 86, you've said that in your statement you provide further information about the limitations faced by the ACNC in revoking the registration.
Yes.
And you've summarised there why revocation, though a serious regulatory intervention, may not fully address misconduct or wrongdoing and or be a blunt tool.
Yes, there's further information under question 3 later in the statement, but It can be a blunt tool because there's two aspects. One is once we revoke the registration of a charity, then if you like, we don't have any ongoing oversight. We can no longer get information from them. We don't have visibility of their assets. We don't have any powers to do anything if there's concerns raised about that entity. And you can still operate as a charity even if you're not registered with the ACNC, because as I said at the start, it's a voluntary system. The other sort of contrary...
Just on that last point, a consequence would flow through to the taxation benefits that the charity receives.
Yes.
So there is a substantial loss for the charity in the event of deregistration.
Yes, so the other side of that coin, if you like, that you've just highlighted, Commissioner, is that it means they will no longer be eligible for any Commonwealth taxation concessions, and for many organisations that might mean that they effectively end up winding up because it can affect their revenue, but it's not an automatic thing that they then actually cease to operate.
And can I take you back to this table that we've been looking at, but on the next page, underscore 0001, the ACNC's information gathering powers, they apply broadly across all classes of charity, is that right?
Yes, that's correct.
And you've made the point in your statement, I think, that those information gathering powers aren't at large, but they need to be connected to ascertaining compliance with the ACNC Act.
That's correct, yes.
And then can I take you to the blue row just below that says removal of responsible entities, and this was the part of the Act I think I indicated I'd bring you back to, Division 100. Is it right that that part of the legislation provides certain powers to the Commissioner to order the removal of responsible persons from charities?
Yes, that's correct.
And is it right that that power can be exercised in circumstances where the Commissioner has a reasonable belief that there's been a contravention of the Act or a non-compliance with a governance standard?
Yes, it has some aspects to it that get a little bit technical, but if you'd like me to step through those. First, I'd just say, as is indicated on the table, that I do not have any power to suspend or remove the responsible person of a basic religious charity, even if they're conducting activities overseas. Secondly, the power isn't about, if you like, protecting the charity rather than prosecuting the individual. So the theory, the nuance behind that is I can only exercise the power to, for example, suspend a person if by doing so it brings the charity back into compliance with its obligations under the ACNC Act. It's not a broad power to say, look, that responsible person has done something wrong, if you like, and therefore should no longer be involved in the charity. It's got to be tied back, and this is probably back to the constitutional point, has to be tied back to, will removing or suspending that person mean that the charity itself is now complying with the charity's obligations under the ACNC Act.
Thank you. And I think you refer to that particular constraint on the removal power in the body of your statement as a significant barrier. Is that how you'd characterise it?
Yes, it is.
And then I might just take this point up with you now and then come back to the table in a minute. At paragraph 113 of your statement, you've noted that the ACNC Act is grounded in certain constitutional powers that may not extend to allowing additional powers to be conferred on the Commissioner from time to time to act against individual responsible persons of charities. And you've gone on to state that if a path for this type of reform can be found, it would assist the Commissioner if a responsible person could be removed in a broader range of circumstances, for example, where the responsible person has been charged and or convicted of committing certain serious criminal offences such that it makes them unsuitable to govern a registered charity. Can I just ask if you can explain in some more detail why you think having that kind of expanded power of removal might assist in the performance of functions under the ACNC Act, or the performance or the achievement of the objects, I should say, of the ACNC Act, given that the function isn't there at the moment?
The reason is, as I said at the start, the sort of guiding star behind the ACNC about supporting public trust and confidence in the registered charities. So being able to rely on, if you're on the register, you're meeting some core minimum things, so you can donate, you volunteer, and government might give you funding. And I think if you put that public lens on it, there are a range of serious crimes and offences where the general public would think that makes that person really not suitable to be involved in a charity. And that's what that reference is getting to.
And can I take you back to the table that's still on the screen, and the last blue row, regulatory or enforcement powers? I just might run through with you some of the powers that are available that you've listed there. So one is to issue warnings, and that might be a warning, for example, that a contravention is apprehended and the steps that might be taken by the ACNC in response if it's not remedied. Would that be an example of a warning? And a power to issue directions. Could that be a direction to remedy a non-compliance in reporting, for example?
Yes, or some other action.
And a power to, over the page, extract enforceable undertakings from registered charities. That's
yes.
And you've also referenced a power that's available to seek injunctions from a court in respect of registered charities.
Correct.
And is it right that each of those powers, regulatory or enforcement powers, are ones that can only be exercised by the ACNC Commissioner in relation to an FRE?
That's correct. The powers, what I like to describe as the sort of full toolkit of a modern regulator, are limited by that restriction, yes.
And they can't be exercised under the current legislation in relation to a basic religious charity?
Yes, that's also correct.
And in your statement, you've identified that it might be useful if the toolkit is...
with basic religious charities, if they've got overseas activities, then that can be different, but the power to remove or suspend a person, responsible person of a basic religious charity, even if it's operating overseas, doesn't exist.
And in your statement, you've identified that it might be useful if these enforcement powers, so issuing warnings, directions, extracting enforceable undertakings, or seeking injunctions, if those powers extended to include all basic religious charities and also other charitable entities that are not FREs. Can I ask you to explain why you take that view?
I'm very mindful that what I'm suggesting here, is bigger than the Commonwealth government. I mean, it would involve state and territory governments. So you're talking of the area of something like a referral of powers or a cooperative scheme. So I think that's important to call that out because it's not a simple fix, or it probably would have been set up differently. The reason we've taken that view consistently is that it is much easier to do our work to the best of our ability if we have a full and modern toolkit of regulatory powers for all the entities that we are responsible for. And it is also much easier for the charities to understand when they deal with us, if they know that, it might be that we are going to issue a warning, for example. And it is quite resource intensive often to determine if an entity is at any point in time a federally regulated entity. We can't seek from that charity information to directly establish that. That's not permitted, so it can be quite time consuming for us to sort of even consider whether they are, and because it can involve ascertaining if the charity is a constitutional corporation, that is tied work that we would need to engage the Australian Government solicitor, so there's obviously a cost with that, a time frame, and sometimes in complex and detailed investigations what you start with changes over time, and it might be that an entity changes its trading activities and therefore was a federally regulated entity and then is subsequently not. So without wanting to burden with a too detailed description, I'm just trying to give the flavour of why it can make it more difficult for us to do our core business.
If you succeeded in advocating for a federally regulated scheme of that kind, so that all entities were subject to regulation, have you given consideration to the sort of increase, if any, in resources you would require in order to regulate across the board?
I have. I don't really think it takes extra resources. I don't think I should sit here as a regulator and not ask for extra resources, but I don't think that's what's required. In fact, I feel like it's much easier when you're training staff, when you're dealing with charities, when we're putting out education and guidance, if we don't have to say, except for this, or if you're that, or explain a concept like federally regulated entity, which is, as I've attempted to do, tried to do it succinctly, but is actually quite complicated. So I think in the way, say, an ASIC has now got, there were different state-based schemes, and then finally there was a nationalised scheme for corporations, having the same toolkit applicable to all charities that choose to apply to be registered and access those taxation benefits would actually simplify it and not require, massive extra resources.
I think I know what you might say to this, but I should take it up with you. The proposition might be put in relation to these enforcement powers. Well, if the ACNC has the ability to revoke the registration of a charity, any charity, for non-compliance with the Act, why is it that these other enforcement powers are sought on top of that for all charities? What would you say to that proposition?
Our mission is not to revoke charities. Our core purpose is to support charities to comply with their obligations so that they can contribute to the Australian community and contribute when they operate overseas. And so those extra toolkit enable us to better do that, to better bring them back into compliance. And sometimes it is a blunt tool, and we'll only exercise it proportionately where we've tried, for example, education support and trying to get them to voluntarily comply. But if we revoke the charity, it might mean that the service that they provide in that remote community is no longer available. And as you identified, Commissioner, if that means they don't get the tax concessions and their funding dries up, they won't be operating, and people who are relying on a domestic violence service in a remote area may no longer get that service. So I think it's important to distinguish about the ACNC as the regulator of charities as opposed to possibly, the business sector and so forth. That is a very different proposition.
I'd like to ask you next about how the ACNC might currently be in a position to deal with specific concerns that could be raised about charities. And just to set the scene, is it right that the ACNC publishes information about registered charities on a register that it maintains, and that's accessible to the public on the internet?
Yes, it's a freely available register.
And I think in your statement you've identified that the ACNC can receive concerns from time to time about organisations from members of the public based on information that they see on the register or elsewhere.
Correct.
You were asked in the notice that was issued by the Royal Commission, to which your statement responded, how the ACNC Commissioner might be able to respond to a concern raised with you to the effect that a registered charity or its responsible entity had advocated or supported violent extremism, had promoted anti-Semitic speakers, or had otherwise engaged in discrimination or vilification on grounds of race. I'm going to take up with you the response that you've given to that question, which I know has a number of elements, but I might try and do so through a vehicle or an example of a basic religious charity that conducts, say, regular religious services out of premises that it maintains, but which also platforms speakers from time to time that may engage or that do engage in racial vilification or hate speech. And I might ask you to assume for that purpose that one or more of the hateful speeches have been delivered by an individual who is also a responsible person of the charitable entity. So if you're with me on that example, currently, is there any governance standard that responds to that concern? By which I mean, do those set of circumstances in and of themselves cause a governance standard that's applicable to that kind of charity to be contravened?
There's no simple direct line that would mean that charity's status would be revoked. No, there's not a simple line. We would have to consider what possible options there are, the degrees and facts of the circumstances.
And I think you've indicated earlier in your evidence and also in your statement that currently you as ACNC Commissioner have no power to remove any responsible person of a basic religious charity.
That's correct.
And you've referred in your statement to the disqualifying purpose test in Section 11 of the Charities Act. This is, if I can take you to it, I think it's paragraph 114.3. Is it right that under that test, a charity cannot have a purpose of engaging in or promoting activities that are unlawful or contrary to public policy?
That's correct. That provision is in the Charities Act, which we administer.
And in relation to the example, the hypothetical that I've articulated, what issues could arise in terms of ACNC officers seeking to identify whether in those circumstances there is or is not a disqualifying purpose on the part of the charity from the kind of platforming of hateful speakers that I've described?
I fear that this gets quite technical, but I'll do my best to explain it step by step. Disqualifying purpose under the Charities Act, there is a distinction that is hard sometimes to understand the nuance, but it refers to purpose, the word purpose, as opposed to activities. So it's possible that the activities, the terrible activities you've described, would be activities, but not of a sufficient level to amount to disqualifying purpose. And it's only if it amounts to the level of purpose that we could consider revoking the status of that basic religious charity under that section of the Charities Act.
So perhaps to draw that out in a slightly more concrete way, would an example of where a disqualifying purpose might not be demonstrated be where you have a religious institution that continues to carry on its regular religious services and its regular community services with no difficulty, but then once a week, say, there's a hateful speaker that delivers a speech in and amongst all of the other activities that the institution continues undertaking?
Are you right that it would have to be part of the consideration around activities and purpose would be the frequency and so forth? I wouldn't go. I think anything that's, when you describe something every week there's a hateful speech and that person is a responsible person and the charity continues to allow that person to do it every week, that would be, I think, a much higher level of concern for us, and you're getting much closer to where we could still consider taking action, because for me that seems more along the lines that the entity, the charity, is allowing that to happen, and maybe you could say, is it allowing it at a level that it amounts to a disqualifying purpose? It's not in fact, advancing religion as its primary purpose. It's, in fact, allowing something that is not in the public good and public benefit. So there is a presumption that advancing religion is for the public benefit, and it is, as other categories of charitable purpose, they are presumed to be in the public benefit, and it can be a very high bar to establish that you have to prove against it being in the public benefit. And I think when you're in the example that you've given me, the hypothetical example, a repeated systemic act like that the charity is in a way condoned and allowed to continue and hasn't taken steps to prevent, that might be getting much closer to that, a rebuttal of that presumption.
And if we modify my example and we prevent this entity from being a basic religious charity so that it's one to which the governance standards may apply, is a potential difficulty with applying governance standard 3 to that sort of situation. First, that the hate speech might not rise to the level of an indictable offence.
Well, that would be where we'd start. Like, is it at a level that it meets the it's a civil matter and it's 60 penalty units or more, or it's an indictable offence? And noting that there have been some changes in this area around hate speech, there are more offences that are now covered. So that's where we would start. But I think if we had, if the conditions around basic religious charities didn't apply and the governance standards did apply, back to the point made before, and we had a greater toolkit, maybe the first step that we could look at doing if the charity wasn't responsive to acting and getting themselves back on track might be that we would look at a warning, or we could look at an enforceable undertaking. We'd have other tools to try and make sure that this was not continuing, assuming it didn't perhaps reach the standard of a conviction under the racial vilification laws.
And can I ask you to go to I think paragraph 173 of your witness statement. You take up there the current content of governance standard 4, which is about steps that need to be taken by charities with respect to their responsible people and making sure, for example, that they're not disqualified from managing corporations. And at paragraph 173, you've said it may be appropriate to consider expanding the grounds on which an individual is disqualified from being a responsible person to include convictions under Commonwealth, state or territory law for serious offences, etc. And you've included within that inciting hatred and racial vilification?
Correct.
Why do you think such an expansion of governance standard 4 would be appropriate or something worth considering?
It, I think, goes back to what I said earlier. It meets more squarely public expectation, public and community expectation, and anything that can give the ACNC, if you like, a bright line around not letting people be involved is more likely to prevent than the charity not doing the things that it is set up to do, its proper charitable purpose.
And the practicality, if I can put it that way, of that kind of amendment to governance standard 4, would that be tied to the charitable entities that are bound in the first place by that governance standard, including whether it could or might be able to be extended to bring in non-FREs and also BRCs?
The governance standards do apply to non-FREs, so just making that clear, but if the governance standards apply to all registered charities, that would assist, obviously, with that. And I do want to flag that while that would help the ACNC, it might involve consideration of the constitutional issues, but certainly I think if you look at that list, I don't imagine there's too many people that would say that if you have had a conviction for any of those matters, that at least for such time until that conviction is spent, that you shouldn't be involved in the privilege, I think, of running a charity.
And if I can synthesise it all in this way, is it right that ultimately the ACNC would lend support to legislative reforms that would enable it to use all its regulatory powers consistently across all kinds of charities?
Yes, we would.
And at paragraph 174 of your witness statement, you've identified the potential of giving the Commissioner a power to suspend a responsible person who's been charged with the kinds of offences that you've identified in paragraph 173, awaiting trial or other adjudication. Why do you think that might be a useful power?
What is helpful, obviously, when people are charged, there's often a long period of time before the hearing, and whether they're convicted, whether they exercise their appeal rights and the like. And I think if we had the power to suspend them at the point of them being charged, you can balance the need for procedural fairness, that they are suspended but not formally removed, as putting them as being suspended pending a conviction. If they're ultimately not convicted, they could resume their role.
And could I take you please to page 47 of your statement? You have a heading there just above paragraph 211 that says multi-layered regulatory law enforcement and intelligence framework, and you refer in that paragraph and then also over the page, paragraphs 202 and 212 and 213, to some of the difficulties that the ACNC can face when considering whether, under Governance Standard 3, a charity has engaged in an indictable offence. I think you've touched on some of this earlier at the point of registration, but can I ask, for present purposes, where can some of those difficulties arise in terms of the information that's available?
The Governance Standard provisions don't actually require there to be a conviction. So it means if we're satisfied that there's a reasonable chance that there has been acts that would amount to an indictable offence or a serious civil matter, the difficulty can be, as you can imagine, we are not a criminal investigation agency, and we're not appropriately resourced for that. So if we contact the enforcement agencies and they say, oh, we've looked at it and it's not sufficient, then it would be, I think, a brave commissioner that would sort of second guess that, even though, you know, the behaviour might be regarded in the media as quite serious. If it's a situation where the agency is still investigating and haven't yet decided whether they're going to press charges or not, again, we wouldn't want to be out in front acting while they're still doing their investigation. And there can be situations where they might think that it's serious, but they don't have the resources or the priority to attach to it. So it can be hard to navigate as Commissioner things that might meet that standard but are not actually have yet resulted in a conviction, and what do you do in the lead-up period. The other aspect that has happened in a couple of cases is we will be working appropriately with other agencies, law enforcement agencies, and we don't want to jeopardise their investigations, and they've actually said to us, please don't notify the charity that you're investigating, please don't revoke them, because that will mean that they have less ability to in fact do their investigation.
And you go on at paragraph 214 to say that it would be useful to have a one front door mechanism to streamline and improve coordination and access to intelligence and law enforcement in matters where national security risks, major crime, money laundering, terrorism financing or other intelligence issues arise. Are you able to expand on what you have in mind there in terms of a one front door mechanism?
I'm very conscious that we're the Australian Charities and Not-for-Profits Commission. As I said at the start, we are relatively new. There are many, many people in the public that don't know we exist, and I think to believe that every person who works in one of those intelligence agencies knows that we exist is also perhaps stretching things. But for us, if there was a single point of contact We are not the day-to-day business for the AFP. We are not the day-to-day business for ASIO. The vast majority of charities on our register are doing the right thing. But we're talking about a very small number at the very, very pointy end, and just wanting to make sure that we are as effectively, efficiently and quickly as possible getting the intelligence from those agencies so we can act wherever possible, and that we can pass on any concerns that we have that might stray into, these very serious areas, and we get it to the right source within the intelligence community as quickly as possible would be helpful for us as a fairly small agency.
Commissioner, I note the time. I have for my own part just one more question for Ms Woodward, but I do understand that there's to be some short cross-examination as well.
I understand that Mr Bender has some cross-examination, so it might be appropriate to take the morning adjournment. Yes. Bear with us for a 15-minute break.
Of course. Thank you, Commissioner.
Ms Woodward, can I take you to page 50 of your witness statement, paragraph 226. This part of your statement contains a response to a question that you were asked about whether it might assist the ACNC in carrying out its functions if the statutory process was introduced for the ACNC to revoke the registration of a charity on security grounds based on formal advice or a recommendation of an Australian law enforcement or intelligence agency. And you have said in response to that question that you think it would assist and that the ACNC would support measures of that kind. Can I ask you to explain why you think a mechanism of that kind for revocation of registration of a charity would be of assistance to the ACNC?
I think again that anyone would expect, if there's national security issues at play, that we should be able to act to ensure that no registered charity is threatening that, and anything that provides a clear and bright line will enable us to act as quickly and effectively as possible.
And is it right that a direction coming to the ACNC from a law enforcement or security agency might overcome the difficulty that the ACNC could otherwise face in terms of accessing for its own part some of the information held by those agencies?
Correct, it would. It would mean that we could rely on the specialist organisations that determine these matters. We're not drawing back on, whether it fits within the nuance of a governance standard or any of the other things that we've talked about in the course of this hearing.
Thank you, Commissioner. I have no further questions.
Yes. Mr Bender.
Would you be aware that in recommendation 23 in the 2018 review, the offences that were proposed as offences that would disqualify a person from being a responsible person were terrorism financing, money laundering, fraud, drug importation and child sexual offences, but at that time the recommendation excluded hate speech or racial vilification offences. Is that right?
At the time of the ACNC review, recommendation 23 that you referred to, the review was conducted, I believe, in 2018, and you're correct that it didn't, in its list, include those offences.
You suggested in your statement, paragraph 173.5, and Ms Phillips asked you about this, the possibility of including convictions, including for inciting hatred and racial vilification, correct?
Correct.
Is it the case that, from your perspective as a regulator in this sector, the societal picture has changed since 2018, and that because of heightened concerns about racial and religious vilification and incitement of hatred, there is a greater need in your sector to consider law reform that could address those issues in connection with charities?
I think that's a fair summary. I think charities are often at the forefront of social issues, and therefore we need to support them to stray on the right side of that in terms of respectful conduct and the important role they play in social cohesion. And if they're conducting those sort of activities, I think it's fair to say that they're not really contributing to social cohesion.
The possibilities that you've raised in your statement to include within the disqualifying offences were convictions for criminal offences regarding the incitement of hatred or racial vilification. Would it be useful also to include as a disqualifying factor for a responsible person a finding that that person had contravened Part 2A of the Racial Discrimination Act, which of course is the part of the Act that includes Section 18C?
I think, again, if someone is convicted under those provisions, excuse me, I don't know if that would be sufficient to amount under the current Governance Standard 3 for the 60 penalty units or the indictable offence. If, to the extent it's not covered, I guess consideration could be given as to whether it's sufficiently serious that it should be covered.
Appreciate that may not be your area of expertise, but it wouldn't be covered because a contravention of Section 18C is not a criminal offence at all.
Right.
It's a prohibition under a non-criminal law.
Yes.
With that added piece of information, knowing that whereas the current standard only applies to offences, and your statement suggested that that be expanded to hate speech offences, my question is, would it be useful to consider expanding it beyond criminal offences, but to circumstances where a court or a tribunal with competent jurisdiction had held that a responsible person had engaged in conduct that amounted to effectively hate speech in a non-criminal context?
I think to a large extent that's the role of this commission to make those recommendations, and we will await to do whatever our part is. But anything that provides us with a bright line that makes it that we're not having to reassess that type of conduct because we're not set up to do that would assist us to play our part in that role.
Are you familiar with a proceeding brought by one of my clients, the Executive Council of Australian Jury, against a Mr Haddad under the Racial Discrimination Act?
I'm aware of the media about the case that was brought against Mr Haddad.
In that case, a finding was made that Mr Haddad had contravened Section 18C of the Racial Discrimination Act. That has no automatic consequence at all under the governance standards, which don't refer to contraventions of Racial Discrimination Act or other non-criminal legislation. And the result of that is that it would have been necessary in order to take further action as the regulator to find some other basis to take action against the charity that Mr Haddad was associated with. Is that correct?
Without talking about the particulars of any charity, because that would involve protected information, in general terms, I think we've covered in the questions to date that if there's an individual responsible person engaged in activity that's, frankly, as a general term, not appropriate for the charity, it goes to, yes, we would have to consider what has the charity done about that activity, how serious was it, the repeated nature, and whether the governance standards apply to that charity or not would be the type of considerations.
And are you referring to the charity's obligations under Governance Standard 5 to take steps to ensure that the responsible persons engage in particular ways?
Yes, that Governance Standard 3 and 5 would be the primary ones that would come into play in this situation.
You say, well, can I take you perhaps to paragraph 169 of your statement, please, Ms Woodward? Do you have that?
Yes, I do.
You're addressing in that paragraph the possibility that Government Standard 5 might be relevant to the sort of conduct that I've been asking about, and you've referred to the authorisation, approval or promotion of extremist or discriminatory or anti-Semitic conduct. Can you see that?
Yes.
Would it be helpful to make it express within Governance Standard 5 that the duty to take reasonable care included a duty to take care to prevent the charity's premises, platforms and events being used for conduct that could amount to racial vilification?
It could be anything that further explains what is covered by those standards could be helpful. I guess there's a whole range of things that activities that perhaps don't meet the standard of indictable offence or a serious civil offence that might be included in there. And I don't think the fact that it's not specifically mentioned means that we wouldn't consider it as being important.
No, I'm not suggesting that's the case at all, and in fact in your statement you indicate that it may be one of the relevant matters to take into account, but because there's no express indication within the governance standard itself, and because reasonable care is a notoriously difficult standard to apply sometimes, would it be useful to specify in the standard that the reasonable care obligation fixes particularly on a duty to prevent the premises of the charity or its platforms or events being used in a way that would amount to, for example, an offence under the racial vilification laws?
It could be. It could be.
Thank you. Now, turning to Government Standard 4, which fixes particularly on responsible persons. Now, I'll preface this question by saying it's the case and certainly acknowledged that part of the approach to regulation in your sector, as I understand it, is to have particular concern to compliance costs because you're regulating charities. That's right, isn't it?
Correct.
So when considering who might be appropriate to be a responsible person of a charity when they come into the board or executive committee, would something like an obligation to undertake social media checks for, let's say, their social media presence over the last 6 or 12 months be a relatively low cost and easy measure for charities to undertake as part of any reform to Governance Standard 4?
I think the thing to remember is that it might seem simple, and I'm not saying it's not appropriate, and many charities do a whole range of screening and processes around who they appoint to their boards. To introduce something that requires them to do it for all 66,000 charities, I think could impose an unnecessary burden on many organisations. And then it's a point in time thing. Are they to monitor the social media accounts of all their responsible people? You know, I mean, social media works very fast, as I'm sure you appreciate. So when you also combine that with consistently over the last 14 years, we've seen that about half of all registered charities are entirely volunteer run, and you put that sort of extra layer on, it can be considered quite a significant extra burden, even though I acknowledge it's a free and possibly simple thing. What we focus our guidance and education on is always trying to say that we have a principle-based system and that charities need to tailor it to their particular needs. So for some charities, monitoring the social media in case people attached to them are involved in horrible situations of hate speech, for example, won't be appropriate because they're a land care group and they're planting trees and it's just not sort of relevant. So what we try and do in our education approach is to always say that think about the particular circumstances of your charity. Are you a charity that is involved with young people and therefore, you know, the standard of dealing with vulnerable people needs greater screening than if you are a small organisation that is, you know, doing something that's quite different to that.
Thank you. Am I correct in understanding that under Governance Standard 4, the disqualification only would apply against appointment if the offence has been committed within the previous 12 months, or is that not how the standard works?
That goes to the ACNC, so there's steps. There's suspension, removal, and then there is the ability to then someone who has been removed can be added to a register of disqualified people, and that the disqualification register is in the last 12 months.
Thank you. Would there be merit in increasing the period for which particular people who have been disqualified might be unable to be a responsible person beyond 12 months?
I have not considered that. It would be a matter for government really as to whether they wanted to change that. We haven't had a situation where I can think of an example where it's like, oh, that's really terrible. I guess we would always have the power that if the 12 months expired, they go to another charity, they go on the board, and we see a repeat of the behaviour that was the cause for which they were disqualified. As Commissioner, I would still have the power to suspend them and maybe, re-put them on the register.
But it seems, at least for you to have the power to extend the disqualification beyond 12 months, not necessarily to do so, but to exercise a discretion in an appropriate case, might be a useful tool in your toolkit, mightn't it be?
It could be helpful. I don't know why 12 months was chosen at a particular time, so I'm not sure if there was a policy reason for that I'm unaware of.
Thank you. The regime in respect of basic religious committees is that the governance standards don't apply, save for governance standard 6. That's correct, isn't it?
Basic religious charities, correct.
And as I understand it, the ACNC supports removing the exemption for basic religious charities entirely. Is that right?
We're concerned to ensure we believe it would be more efficient and basically fair that the same standards apply to all registered charities, noting that the reporting obligations are proportionate to size. So if you're a very small religious organisation, you may not have to lodge financial accounts based on your size, whereas at the moment it doesn't depend on size, for example.
If for some reason Parliament decided not to exempt basic religious committees in accordance with what you've proposed, would there be a halfway position that could be useful, which would be to continue to apply to basic religious charities some of the obligations in respect of hate speech and religious and racial vilification only?
I guess there's a variety of ways that changes could be made. You could carve out something like that. As a general implementation comment, I would say that everything that makes the system more complicated to explain does make it harder for us. So you're trying to produce education materials, you're trying to do explain it, and then you always have to say, oh, with this exception or for this bit, I think can sometimes make it more complicated. But that might, if that was something that happened, we would do our best to implement it.
Well, at the moment, as I understand it, basic religious charities are already subject to governance standard 6.
Correct.
And it, I would have thought, could have been done relatively simply to apply one of the other governance standards or part thereof to a basic religious charity, such as a requirement that their responsible persons not have been convicted of racial vilification offences.
It might be, just taking your example a little bit, you could say that they're exempt except from, say, governance standard 3
right,
and governance standard 6. So I would suggest that that would be an easier thing to explain rather than a sort of very minor, not minor in importance, but technical sort of subset of another standard becomes quite complicated. And bearing in mind the part of the original advocacy around creating the exemption was to make it as simple as possible for small faith-based organisations to comply with this new regime.
My last topic is about the challenges you face in regulating the non-federally regulated entities. So is it correct that insofar as a charity has some cross-border operations, then you might be able to regulate them because of the constitutional power in respect of external affairs, but that only applies to about 6% of charities that you regulate?
Yes, our data shows that about 6% of charities report activities conducting activities overseas.
Ms. Phillips asked you some questions about other charities that aren't in that category that may be federally regulated entities, and you answered that it can be quite difficult to tell the difference in effect. Are you able to assess approximately the proportion of charities under your purview that you're unable to apply the sanctions you've referred to because they're not federally regulated entities? Is it more than half, for example?
I have asked this question when I became Commissioner, and I have not yet been able to get any reasonable answer, and I understand why, because it is a point in time. And the briefing that I got was that actually probably the vast majority are not federally regulated entities because they don't satisfy that definition of a constitutional corporation.
So, assuming that briefing to be correct, it follows that in respect of the vast majority of charities you regulate, your regulatory toolbox is really revocation of the status as a charity. Is that right?
That's correct.
And that's a blunt instrument, to put it mildly, including because it would end your regulatory oversight over that body.
That's correct.
You've described that as an insufficiency in your enforcement powers. It's really quite a stark insufficiency, isn't it?
I think we do a pretty effective job with the tools that we've got. And a lot of times, because you don't get to the pointy end of the regulatory pyramid where you are, dealing with really persistent, serious breaches that are, in the serious fraud category or likewise, we can achieve an awful lot with the powers we do have, because quite often when we just contact the charity, they go, "Oh, whoops, yep, you've got us, and we'll do something about it," or we'll issue regulatory advice, or we get a compliance agreement. So there are many other steps where no one sees it because it's not public, but we do effectively regulate organisations that are straying outside the bounds that we would like them to be in, even though we don't have the full regulatory toolkit. Yeah.
Sorry.
I do want to give that assurance so that the public don't think it's like, free for all. It's certainly not. But it does mean that would make it more effective and give us more chance to help ensure that a charity is on the right path and doing what it's set up to do.
And when you say it would give you more chance to do those things, do you mean having your powers expanded in a way that didn't have the division between federally regulated and non-federally regulated?
Yes, if I could. As I tried to acknowledge at the start, I'm sitting here suggesting something that people, referral of state powers is not an easy thing to talk about, and but I've been asked the question both in the request I got for a statement, and you're asking me now, and the answer is that if it was possible to have the full toolkit, which would, draws on our constitution, it would assist the ACNC.
And of course, another way to do that wouldn't require referral of state powers would be the enactment of a national scheme of legislation where each of the state parliaments also empowered you in a similar way to what's occurred under the Australian Consumer Law, the Corporations Act, correct?
Yes, I'm not holding myself out as a constitutional lawyer. That's not my role, but it's not my policy remit. But whichever way you did it, having those powers would be very helpful.
Thank you, Ms. Woodward. Thank you, Commissioner.
Mr. Kaplan, anything arising?
No, nothing arising,
Ms.
Commissioner.
Phillips.
Just one matter arising.
Yes.
Ms. Wood, Mr. Bender took up with you governance standard number 4 and the condition that a responsible entity has not been disqualified by the Commissioner within the last 12 months. And it was taken up with you by Mr. Bender that perhaps that 12-month period could be increased. At the moment, does the ACNC Commissioner have a power to allow an individual who has been disqualified within that last 12-month period to nonetheless be the responsible entity for a particular registered entity where the Commissioner believes it's reasonable to do that in the circumstances?
I'd have to, perhaps you can direct me to I think it's covered in my statement. I think there is some discretion there The example sometimes given is that someone has been convicted of offences but then is also assisting a charity that's dealing with ex-offenders and has a role to play. I'd have to check that provision to be sure about that.
I can perhaps give you a
Thank you.
regulation number. I can put it on the screen if that would assist.
Thank you.
RCD.50001.0092 and operator, it's pages 11 and 12 of the print.
I think is it regulation
Regulation
45-20-5?
Yes.
The Commissioner may allow an individual to be a responsible entity, so that's the director of a charity, if you like, for a particular registered entity, particular charity, if the Commission believes it's reasonable to do it so in the circumstances.
So
Yes.
if the disqualification period was increased from 12 months to some greater amount of
Yeah.
time, that carve out, if I can put it that way,
Would
could
still-
still operate.
Yes, yes.
Thank you, Commissioner.
Thank you, Ms Woodward.
Thank
You're
you.
now excused.
Thank you.
Commissioner, I call Diane Brown.
Yes. Ms Brown, will you take an oath or make an affirmation?
An affirmation, please.
Please stand and face the Commissioner. Do you solemnly and sincerely declare and affirm that the evidence you shall give will be the truth, the whole truth, and nothing but the truth? Please
I
say
do.
I do.
I do.
Thank you. Do sit down. Yes, Ms Phillips.
Can you please state your full name?
Diane Mary Brown.
You are the Deputy Secretary of the Revenue, Small Business and Law Group at the Australian Government Department of Treasury,
That's correct.
and you've prepared a witness statement dated the 29th of July 2026.
That is correct.
Is that statement true and correct to the best of your knowledge and belief?
Yes.
Commissioner, I tender the statement STA.0542.0001.0001_R.
Yes, the statement is admitted.
The Revenue, Small Business and Law Group within Treasury is responsible for policy work which concerns the taxation of charities and not-for-profit entities, standards of governance for these entities, and also the enabling legislation for the Australian Charities and Not-for-Profits Commission. Is that right?
That's right. That's part of the responsibilities of the group.
And you've given some background context in your witness statement about the nature of Australia's charity sector, and you've identified that the sector comprises a wide range of entities.
Yes, it is a very diverse sector. It ranges in size and nature of activities, the structure, which just makes it an interesting, complex sector that we have to have regard to when thinking about new laws.
And you've given an example of revenue ranging from lower amounts in the thousands or tens of thousands to in excess of $100 million a year for different charities.
That's right. Some charities are very big. You can think of some of the ones that are more familiar, like the Smith family, organisations like that too. Then quite small charities that are much more locally
Can I
focused.
just ask you to speak up a little into the microphone if possible? Thank you
Certainly.
so much. And you've also noted that as a result of some of those differences, the governance arrangements and the levels of sophistication across different charitable entities can vary quite markedly.
That's right. As the ACNC Commissioner said, they can range from volunteer-based organisations to much more professional, sophisticated organisations.
You've outlined how in your witness statement that in about 2018 an independent review was undertaken of the ACNC Act, and you've described this in your statement as the ACNC legislation review. To your understanding, is that a review that was conducted pursuant to a statutory requirement to undertake a review of the work of the agency and the Act itself after the first 5 years of operation?
Yes, that's right.
You've set out the terms of reference for the ACNC legislation review in your statement at paragraph 8. These required the review panel to evaluate the suitability and effectiveness of the ACNC legislation?
That's right. It's not unusual with a substantial new bit of legislation to have a review after a period of 3 to 5 years to see that it's operating as intended.
And you've identified that one aspect of the terms of reference, this was at paragraph 8.3, was to have consideration of whether the powers and functions of the Commissioner of the ACNC were sufficient to enable the objects of the legislation to be met and whether any amendments to the Act were required. Is that right?
That's right.
And the report that arose from that ACNC legislation review was published on or around the 31st of May 2018. I think you've explained that the report made a total of 30 recommendations, of which 24 recommended action by government. Is that right?
That's right.
And you've noted that on the 6th of March 2020, the then government response to the ACNC legislation review of 2018 was published.
That's right. The government always considers reports, and after a period of time will release a report, a response.
I'd like to take you to particular aspects of that review and then the government response to it. Picking up perhaps first at paragraph 11 of your witness statement, you've commented on recommendation 18 of the legislation review. Do you understand that recommendation 18 was a recommendation that the Commissioner of the ACNC be authorised to collect the personal details of responsible persons involved in unlawful activity?
I do understand it was a recommendation of the ACNC.
And can you explain your understanding of what that recommendation had been directed to achieving?
The recommendation 18 called for the Commissioner to be able to collect the personal details of responsible entities, being responsible persons in plain air language. It was to help the Commissioner to understand whether charities are being run by properly or suitable people.
And a further recommendation that you've addressed arising from the ACNC legislation review was recommendation 23, and I'll just read that out to you. It said that the Australian Charities and Not-for-Profits Commission regulations be changed to disqualify a person from being a responsible person if they have a conviction for terrorism, terrorism financing, money laundering, fraud, importation or distribution of illicit drugs, or a child sexual offence under Commonwealth, state or territory law. Is it your understanding that at present, as the legislation stands, these types of convictions would not on their own currently provide grounds for disqualifying an individual from being a responsible person of a registered charity?
I believe a person can be disqualified if they don't meet the conditions to be a director of a corporation. These offences may disqualify them on that grounds, but if it was an offence not involving dishonesty, it wouldn't. And so this was to make it more explicit that it was about whether they were being honest or dishonest.
Can I take you please to the government response to the ACNC legislation review, dated the 6th of March 2020. It has doc ID ACN.6000.0001.0879. I think it's behind tab 5 in the bundle you have.
Mm-hmm.
And if I can ask the operator please to turn to page 15 of that document. You'll see that down the bottom of that page it deals with recommendation 18, and it refers to, on the left-hand side of that table, the finding of the panel that the ACNC should be able to request details on the criminal records of responsible persons to allow it to detect unlawful behaviour and contraventions of the ACNC Act. And then you'll see on the right-hand side, the government supports the recommendation as it will enhance the ACNC's capacity to detect breaches of its governance standards and external conduct standards. Now, just unpacking that a little bit, at the moment, how do you understand that the ACNC having this kind of information could assist it in its regulatory activities under the powers that the ACNC Commissioner currently holds?
So if they had the ability to collect more details of responsible persons, they could be better equipped to understand whether a charity is being managed by suitable people. That would involve a change in how regulators often work. Regulators often take very much a risk-based approach to their work, and so the provision of information or additional information without cause or suspicion may not necessarily change how they work, but it would give them the capacity, if they wanted to become what we call a more active regulator, to have more information at hand to make the type of assessments as to the suitability of responsible persons.
And can I ask the operator please to go to page 18 within this document? You'll see at the top there's the response to recommendation 23, and it says in the left-hand side in the black text, the panel found that the current disqualifying criteria for responsible persons is too narrow, limiting the ACNC's ability to prevent individuals linked to serious criminal activities, including terrorism financing and money laundering, from being responsible persons of charities. And then in the first line in the right-hand column containing the government response, it says the government supports the recommendation. And then it goes on to say, while proven instances of criminal misconduct in the sector remain low, illicit activity could severely damage public trust and confidence in the sector and harm the communities they are working to assist. Pausing there, would you agree with that observation or statement, that is that illicit activity by responsible persons of charities could severely damage public trust and confidence in the sector?
It would. I agree with that.
And you'll see that those comments in the government response column have been provided in relation to a proposed pathway for disqualification of persons from being a responsible entity of a charity if they have convictions of the kind mentioned there, terrorism financing, money laundering, fraud, drug offences and child sex offences. Could it also affect public trust and confidence in the charity sector, where responsible entities of charities are permitted to continue in that role after being convicted of hate-based crimes such as inciting racial hatred or inciting violence on grounds of race or religion, so 93Z of the Crimes Act or 93ZZA of the Crimes Act in South Wales, for example?
I think that would be a reasonable statement to make. People would expect people running charities not to be engaging in that type of behaviour.
And what would you say about contraventions of civil law discrimination provisions, such as the prescription in Section 18C of the Racial Discrimination Act, which is a civil provision prohibiting racial discrimination? Might it be the case that if responsible persons of charities are involved in those kinds of contraventions, that could also cause a damage of public trust and confidence in the charity sector?
We have looked at that. I think that is a reasonable expectation, though what is reasonable in the case of a law is always a matter for government, and they really are probably the better judge of what is going to affect public confidence. But I think my view is that would be a reasonable expectation, that a civil offence would also cause a lack of confidence or damage confidence.
Thank you, operator. That can come off the screen. In your statement, you have identified that there has been consultation on proposals to implement recommendations 18 and 23 from the ACNC legislation review, but that neither of those recommendations have been implemented. That remains the case currently?
That's the case currently, yes.
And you've also identified in your statement that constitutional limits on the legislative powers that may be conferred on the ACNC Commissioner could affect the ability to implement recommendations 18 and 23. Currently, does Treasury have a view about whether legislation conforming with those recommendations in their terms would be within the legislative powers of the Commonwealth?
So the Commonwealth, Treasury in developing legislation would seek the advice of the Attorney General's Department or the Attorney General Services as to the constitutionality of legislation. It is the expectation that Commonwealth legislation be within the Commonwealth's powers. But my understanding is that, yes, we would consider that the ACT doesn't currently have the power to routinely collect information from responsible persons directly.
And you've said in that answer there, currently doesn't have the power. Can I take you to paragraph 23 of your witness statement? In the second sentence of that paragraph, after referring to recommendations 18 and 23, you said conferring this power on the ACNC in relation to all registered charities would likely fall outside the legislative powers of the Commonwealth. That's the current view of Treasury.
That's the current view, yes.
And it may be that you're not in a position to answer this, but is the key constitutional issue that might confront legislation that directly sought to enact recommendations 18 and 23, that such legislation might purport to directly regulate individual representatives of charities rather than the charitable organisations themselves?
Yeah, the issue, as I think in my paragraph, maybe I haven't put it in my statement very well. There isn't a head of power in the Constitution in relation to charities explicitly. So the Commonwealth has to use a range of constitutional powers. As Ms Woodward said, they range from corporations, external, territories, taxation. In relation to the taxation power, which is probably the one that my group is most familiar with, the ability to obtain a tax concession can be granted on conditions, but that would be in relation to the entity, the taxpayer. So it wouldn't apply to it would apply to the charity rather than the responsible person.
And at paragraph 24 of your statement, you've said that this constitutional issue could be resolved by a referral of legislative powers from the states if the Commonwealth proposed to make laws on this matter. Just to clarify that statement, is what you're indicating there a position that if there were a referral of legislative powers by the states in relation to taking action in respect of responsible persons of charitable entities or registered charities, that could solve the present limitation that's understood to exist in terms of enacting legislative powers for the ACNC Commission to exercise?
I'm not a constitutional lawyer, but that would be my understanding. As Ms Woodward said, the residual powers sit with the states. So if they were to refer them to the Commonwealth, that would give the Commonwealth the power to make laws in respect to those matters.
And in your statement, you've also addressed, from around paragraph 25, the need when enacting any legislation in this space to consider the regulatory burden of legislative reform on charities. Does that need in practice means that when considering policy design proposals, one sometimes needs to try and strike a balance between, on the one hand, measures that are seen to promote public trust in the sector, and on the other hand, the need to minimise, where possible, some of the administrative red tape, both for charities and donors to charities?
It does, yes. It is government policy to try and assess regulatory costs on new initiatives, and sometimes you will change what you do if what you had proposed would have imposed a unreasonable regulatory burden on the affected parties. It's probably particularly pertinent in this sector where the Act has both those two objectives you said, one of encouraging or maintaining confidence in the sector, but two, also reducing any unnecessary regulatory burden in the sector.
You've outlined in your statement from paragraph 29 that as a consequence of some of the considerations that you've described, whether they be regulatory costs or constitutional limits, that Treasury has considered alternative ways to implement the intention lying behind recommendations 18 and 23 arising from the ACNC legislation review. I might start by taking up with you the alternative option that's been canvassed in relation to recommendation 23, and you've addressed this at paragraphs 32 and 33 of your statement. Are you able to explain the way in which Treasury has considered to date trying to give effect to the object of that recommendation through law amendment?
Certainly. So recommendation 23 was about giving the Commissioner more powers to remove or disqualify people from acting when they were unsuitable in the role. Governance Standard 4 puts on charities an obligation to take reasonable steps to ensure that they only appoint reasonable persons. This was adding to the factors that they would need to consider in assessing their suitabilities. And I think, as we discussed earlier this morning, if they don't take those reasonable steps or don't act appropriately, that gives the Commissioner power to examine them and potentially to revoke their registration, and that could lead to a loss of valuable tax concessions to them. And so there's an inbuilt incentive there to try and make sure you appoint the appropriate people, which is equivalent to, well, it's a mirror, it's not quite a mirror, but it's analogous to the Commissioner being able to remove unsuitable people.
And so just to be clear, your understanding is that the current governance standards that are in place require charities who are subject to them to take reasonable steps to be satisfied that their responsible persons meet the existing conditions, and the proposal, as you've articulated it, is to expand that governance standard so that the charity will need to take reasonable steps to ensure that the responsible persons are subject to additional conditions.
That's right.
And those additional conditions include taking steps to ensure that the responsible persons are not subject to convictions for particular offences?
That's right, as set out in paragraph 34, noting that that related to a response to the ACNC review, which was made in 2020 and reflected the environment existing at that time.
And at present, the addition that you've described in paragraph 34 of your statement, is that an amendment that Treasury considers would overcome some of the constitutional impediments that might arise for a direct implementation of recommendation 23?
That's right.
And if the amendment that you've outlined there, or the potential amendment for Governance Standard 4, was also extended to include other crimes, such as hate crimes, and also contraventions of civil discrimination laws like Section 18C of the Racial Discrimination Act, do you understand that that kind of extension would similarly avoid the sorts of constitutional issues that you've raised?
Yes, I think later in my statement I talk about the response to the Special Envoy's recommendation, and we made that suggestion, so we think it would be possible.
And can I then ask about the proposals you've outlined at paragraph 30 that Treasury has considered for addressing the rationale underpinning recommendation 18 regarding collecting information related to convictions of responsible persons? Can you explain the options that have been contemplated there?
So they are as set out in paragraph 30 of my statement, and it is about various ways that the charities could be obliged to become aware of more of the background of their people they're proposing to nominate as responsible people or maintain as responsible persons.
And under that proposal for giving effect to the rationale underlying recommendation 18, which is to put an obligation on charities to certify matters concerning their responsible people or responsible entities, does Treasury consider that the constitutional impediment to regulating individual responsible persons would be overcome?
We believe so, yes.
And you've identified that there could be some regulatory costs involved in a proposal to require registered charities to certify that responsible persons meet various criteria, including not having disqualifying convictions. Where do you see those regulatory costs arising under that kind of an amendment?
So I will indicate they were numbers done in 2020, so they're probably a little bit dated. But they arise from the time the charity needs to undertake the checks, to make provide additional information in their statement, as well as the costs of obtaining the police checks.
Could there be an option to amend the standards that apply so that charities are required to give the certification of non-conviction, if I can put it that way, but aren't expressly required to take the further step of obtaining a police check for that purpose?
It could be. Often when there's obligations like that, though, people like to be satisfied that they are making true and correct statements.
But for a smaller charity, say, with only one or two people responsible for the management who might be in a position to know whether they've got a relevant conviction, that would be arguably a superfluous requirement for them to satisfy themselves?
It could be. It would be up to them how they satisfy themselves. And if they know each other well, if it's small, they could be confident in certifying that there is nothing that disqualifies them. But in other organisations, they may, as a matter of prudence, want to get police checks. So charities could respond in a variety of ways, which is why I think we indicated later in our statement that that's something, if we were to implement this, we would want to consult on further to understand how the sector may respond and understand how that may affect the sector given its diversity and, as we said earlier, its size and activities.
But the first option in paragraph 30 takes up Council's suggestion. There is no requirement to obtain a police check. What one depends upon is the charity's certification of non-criminal conviction.
That's right, Commissioner. And that could be reinforced by the Commissioner, for example, giving guidance to indicate that's sufficient.
Subject to some of those further consultations that you've just referred to, at present, is Treasury open to the alternate pathways that you've described in your witness statement from paragraphs 29 to 36 for giving effect to the policy rationales behind recommendations 18 and 23 of the ACNC legislation review?
So I think it's always a matter for government, the type of work we do and the amendments we progress with, but this is the nature of the how we would currently see it best being implemented.
And I think you indicated in your statement that at present there's no active progression of implementation, and that's because the Royal Commission's on foot.
That's right.
The July 2025 plan, released by Gillian Siegel, the Special Envoy to combat anti-Semitism, contained as one of its key actions a proposal to remove deductible gift recipient status from any charitable institution which promotes speakers or engages in conduct that promotes anti-Semitism. You're familiar with that document and that key action contained within it?
I am, yes.
Are you aware that in the government's response to the Special Envoy's plan that was released on the 16th of December of 2025, the response said broadly that the government adopted the plan?
That's right.
And do you know whether the government's response contained any express or specific engagement with the key action that was relating to DGR or deductible gift recipient status at
So
that time?
it didn't include explicit reference to this. It included reference to doing further work on recommendations or key actions that were not referenced explicitly in the statement.
And has Treasury or through your group undertaken that further work in terms of giving consideration to how that key action might be able to be implemented and whether it's prudent to do so as a matter of legislation?
We have considered. We have given it consideration. Yes.
And I think in your witness statement you've expressed that there might be some reservations about direct, in a similar way to how there are some difficulties or limitations to directly implementing recommendations 18 and 23, that there might also be some limitations for a direct implementation of the key action in the Special Envoy's plan. Is that right?
I think it might be a slightly different twist on it. It's not necessarily a constitutional issue. It's one of regulatory framework. The Commonwealth currently has a regulatory framework where the ACNC is the regulator of charities and the ATO is the collection agency, a tax collection agency. DGRs are administered by the ATO. We would be conscious to try not to duplicate the regulation of charities. We could give the power to the ATO to revoke the DGR status, but they would be doing it for matters around behaviour of charities, and the behaviour of charities probably more appropriately sits with the ACNC, which is why we were looking at the ACNC as being the vehicle, or its standards being the vehicle through which it would happen, it could occur, and then you have the constitutional powers that you need to consider.
And is it right that broadly Treasury is looking at a mechanism that might respond to some of the policy rationales, if I can put it that way, underlying the Special Envoy's proposal, that is sort of through an amendment to the governance standards for charities?
Yes, that's right.
And at a high level, and I'll come to the particular amendments in a moment, is that mechanism of tweaking the governance standards something that's being looked at because a breach of a governance standard can give potentially a ground for deregistration of a charity that's otherwise registered with the ACNC?
That's right, and I think that's the other advantage of doing it through the ACNC standards is that if the charity is revoked, they lose access to all of the tax concessions that they may be available to, not just the DGR. So if the issue is about the expenditure of public money by a charity that's engaging in inappropriate behaviour, we wanted to make sure we dealt with both the DGR as well as income tax and any other tax concession they may be availing themselves of.
And where ACNC registration as a charity is the hook, as it were, for attracting various tax concessions, not only deductible gift recipient status.
That's right.
Then deprivation of that registration removes those entities from the benefit of the suite of charitable tax concessions.
That's correct.
And can I take you please to paragraph 47 of your witness statement? You've outlined there some amendments to the governance standards that Treasury has in mind to meet some of the concerns, I think, that have been raised by the Special Envoy. Can I ask you please to outline those amendments both to Governance Standard 3 and then to Governance Standard 4 that are being contemplated?
So Governance Standards 3 deals with compliance with Australian laws, and the amendment was proposed to prohibit a registered charity from engaging in an act or omission that is a summary offence related to racial vilification or hate, and that is paragraph 47.1. 47.2, paragraph 47.2 concerned Governance Standard 4, which is about the suitability of responsible persons, and that was amending it to make it a condition that a responsible person not have a criminal conviction for racial vilification. And we would also at the same time deal with recommendation 23 of the ACNC review and deal with the other offences that were listed in that recommendation, so terrorism and terrorism financing, etc., as set out in paragraph 47.2.
And broadly, if the ACNC governance standards were to be amended in the manner that you've described in paragraphs 47.1 and 47.2, could that allow the ACNC to deregister charities in a broader range of circumstances to the current position?
It might be more a question for Ms Woodward. The regulatory always needs to be proportionate to the offence, but it could, in the appropriate circumstances, allow for revocation or deregistration.
And in relation to Governance Standard 3 that you've referred to at paragraph 47.1, if that were amended in the manner proposed, that is to also prohibit registered charities from engaging in offences, including summary offences related to racial vilification or hate, do you know whether that form of amended standard would be breached whenever an officer or a staff member of the charity might engage in that kind of conduct?
Again, it's really a regulatory matter, and it would be a decision of the regulator as to whether it amounted to a breach.
But at the level of principle, is it the case that Governance Standard 3 is a standard that applies to criminal conduct by the entity, and when working out whether an entity has engaged in an offence, there's first a process of seeking to attribute any conduct by individuals associated with the entity to the entity itself?
I think that's correct. Yes.
And so, could it be said that a potential limitation of amending Governance Standard 3 in the way that's proposed at paragraph 47.1 is that it might not give rise to a contravention of the standard each time a person associated with a charity engages in that sort of conduct, and one needs to bring it back to the organisation itself? That's
right. And I think that also goes to Ms Woodward's earlier evidence around activities and purpose as well.
And picking up the proposed amendments at 47.2 of your statement to ACNC Governance Standard 4, is your understanding that even with the amendments here that are proposed, that you've outlined, do you understand that would not give the ACNC Commissioner a general power to remove persons from registered charities who have the requisite criminal convictions?
That's right, it's not a direct power.
And do you understand that the standard currently cuts in at the point of whether the charity itself takes reasonable steps to ensure that its responsible person doesn't have the relevant convictions? It doesn't cut in at whether they do or don't in the first place.
That's right. The obligation is on the charity, and it's one to take reasonable steps.
And at the moment, just to confirm some of your earlier evidence, does Treasury consider that in order for the ACNC Commissioner to be able to ban or remove people with certain convictions from being a responsible person of a registered charity, there would need to be a referral of power from the states?
If I can, with the exception of federally registered FREs, that would have. I understand that would be the case.
And does Treasury consider at present that it would be desirable to initiate a process that seeks that referral of power?
Again, that would be a decision of government. I do note that any referral can take a period of time. I've been involved with 2 referrals. One was the Corporations Act. It happened quite quickly, so I won't say it's without exception that it can occur quickly. It had the support of the whole business community to occur. The second one related to housing. I had that role for 12 months. And over that period, we didn't get the referral that we wanted. I think it took a matter of years. So it does require a lot of cooperation between the Commonwealth and the states, and a shared interest in doing so.
And can I take you please to paragraph 55 of your statement? You've noted there that section or subsection 45-10, subsection 5 of the ACNC Act provides that the governance standards do not apply to a category of charities called basic religious charities, of which there are around 8,500. I think in Ms Woodward's statement she's identified that as approximately 8% of total registered charities. Does the consequence, does it follow from that for basic religious charities within that group, amending the governance standards in the way that's been outlined at paragraph 47 of your statement wouldn't provide the ACNC Commissioner with additional powers of regulation, including to deal, for instance, with the issue of racial vilification by a responsible person?
That's right.
I think it's also, you've identified that section 199-5 of the ACNC Act provides that a responsible person of basic religious charities cannot be removed or suspended by the ACNC Commissioner, even where their conduct is related to overseas conduct.
That's right.
And that basic religious charities are also not subject to the same financial reporting requirements as other registered charities.
That's right.
And your understanding, is it your understanding that basic religious charities, by definition, are not deductible gift recipients?
That's right.
But do you understand that they still may be entitled to other tax concessions, such as an income tax exemption?
They can be.
And might a view be taken that trust in the charity sector could be affected if basic religious charities, even if they're not DGRs, can continue to receive tax concessions where their responsible persons engage in conduct like racial vilification?
It could do, yes.
We've heard this morning from the ACNC Commissioner, Ms Woodward, a suggestion that the distinction that currently exists in the legislation between the regulation that's applied to basic religious charities and other charities might be removed to expand the regulatory powers that are available to the Commissioner in relation to basic religious charities. Does Treasury have a view on the removal of that distinction?
So they've always been exempt ever since the Act was legislated. I did have a look at the explanatory memorandum over the weekend, and unfortunately it is silent on why they are exempted. It was recommended by the ACNC Acts Review and again by the Productivity Commission. I think they see it would encourage transparency, and that would be one way of supporting confidence in the sector. To counterbalance that is the nature of these bodies. Many of them are just the local parish church, and so there would need to be an examination of the appropriateness of the ACNC Commissioner, for example, being able to remove a priest from their role. You'd have to think, and I think you could think of ways to manage or mitigate that, but I haven't to date, but it's something I think you would want to consider as part of any amendment to the application of the ACNC Act to basic religious charities.
Another matter that emerged from the evidence today of Ms Woodward is the distinction within the ACNC Act between federally regulated entities on the one hand and non-federally regulated entities on the other, and the difficulty that can sometimes arise in distinguishing between those categories of entities. And an area in which Ms Woodward indicated that that distinction can be relevant is in respect of the availability of various enforcement powers. And examples that she gave were the power to issue a warning, to issue a direction to a registered charity, to extract an enforceable undertaking, and to commence proceedings seeking an injunction. Each of those enforcement mechanisms being ones that are available to the ACNC Commissioner as regards federally regulated entities, but not as regards other entities, just to set the scene. And Ms Woodward in her evidence suggested that there might be able to be an extension of what she described as that enforcement toolkit, so as to be available for all charities, not just federally regulated entities. Does Treasury currently have a view on that kind of a proposal?
We don't currently have a view. I think the Act was introduced in 2012, consistent with the Commonwealth's powers, and consistent with the objective at that time of trying to improve confidence in the charity through more reporting and through more guidance to charities. The legislative framework often has to evolve and mature over time. So if I look at it in a different situation, the regulation of financial advisors is assumed as a given today. They weren't regulated or licensed until 2002. So all acts kind of evolve and mature as we become more familiar with the environment. So I think it would be open to government to consider whether it's appropriate to consider its founding if we couldn't get additional powers to enable a wider toolkit across all of the charities that are captured by the ACNC Act. But that would still be done in a way consistent with the objectives of the Act, which is to try and reduce unnecessary regulatory burden in the sector, but balancing that increasing confidence in the sector.
And we heard some evidence from Ms Woodward that the ACNC Commissioner does have a power to deregister all charities, assuming that the conditions or the criteria for exercising that power in the Act, such as a breach of the ACNC Act, are enlivened. But she described that particular power, in her words, as a kind of a blunt tool. Is that a characterisation or an observation that Treasury has looked at in terms of the potential to expand the toolkit?
I don't think I can say we've looked at it sufficiently to have a view at this time.
A final matter that Ms Woodward raised in her evidence was a possible basis on which the ACNC might be able to find out information about registered charities within its remit from other Commonwealth agencies, and also a basis on which it might be able to revoke a charity's registration on receipt of particular information, for example from law enforcement and intelligence agencies. Are those kinds of options or areas for reform matters that Treasury has given any detailed consideration to?
Sorry, I got slightly distracted. So tell me if I'm not answering your question.
No, I think it was too long, the question, so I might break it up. One matter that Ms Woodward raised in her evidence was a concept, in her words, of a one-stop shop for the ACNC to receive information from law enforcement and intelligence agencies, and she raised a concern about the ability of us to access that kind of information. That component of her proposal, is that something that Treasury has looked at?
So Treasury has looked at that in the context of the ACNC Acts review. I think it was recommendation 22, did look at encouraging the ACNC to work closely with security agencies. Some changes were made at that time to enable the ACNC to get certain information. I think that work is ongoing. The government has given a lot of funding to the security agencies in recent time to try and address at least terrorism-related activities. The issue of giving the ACNC information to access to all the information is something I'd want to give further thought to. It was something we'd want to consult with the security agencies on to maintain for many of the reasons that Ms Woodward said, the effectiveness of their enforcement their regulatory activities, and the sensitivity of the information.
And perhaps a related matter, and perhaps the flip side of the coin, that Ms Woodward raised was a potential pathway whereby the ACNC could receive a direction or a notification from a law enforcement or intelligence agency that could be an automatic trigger for the deregistration of a charity. Is that a pathway that Treasury has looked at?
It's not a pathway we've thought of in this regard, but it is a relatively common pathway, or it's not, I wouldn't say common, but it's not without precedent. A lot of tax laws involve co-administration, where the matter needs someone else to make a determination so that the tax the ATO in this case can make a decision on the availability or continuing availability of the concession. So it's a mechanism that I'd be familiar with and I think could operate more effectively.
And to the extent that the constitutional limitations on conferring powers on the ACNC Commissioner persist, in respect of the areas that we've been discussing, does it remain possible to deal with the kind of concern that the Special Envoy has raised about DGR status being accorded to entities that engage in hate speech and the like, by giving a specific power to the Commissioner of Taxation to remove the endorsement in respect of that kind of behaviour?
So yeah, if I understand the question correctly, I think whether it be with the ACNC or the ATO, both would benefit from another body better equipped to make those decisions, making that decision and it then being an automatic flow on to them revoking the access to the DGR or other tax concession.
Thank you. Commissioner, I have no further questions.
Yes, Mr. Bender.
Thank you, Commissioner. Ms Brown, I appear for 7 Jewish community bodies. I think you were in the room when I examined Ms Woodward, weren't you?
I was.
Thank you. I'll just put to you some of the points I put to her to see what Treasury's response would be. I know that it goes beyond anything that was within the recommendations from the legislative review, so you may not have had time to consider it. But from your perspective, would there be any impediment to making it express within the duties in Governance Standard 5 that one of the things in respect of which care had to be taken was the prevention of the commission of racial vilification offences?
I haven't given it any thought, but I can't think of any immediate barriers to that.
Thank you. In relation to Governance Standard 4, Treasury's own options for recommendation 18 would already have charities running checks on incoming responsible people, including police checks. Of course, a police check would only find a conviction, whereas criminal hate speech online is often never prosecuted. With all of that in mind, would there be some desirability or any impediment to the requirements on incoming responsible persons, including social media checks with a view to detecting criminal hate speech?
So I think similar to what the ACNC Commissioner raised, we would want to see the regulatory impact on the sector of doing that. But beyond that, I'm not aware of any other impediment.
And by regulatory impact, I assume you mean the cost and the extent of work that would be required to comply with the additional requirement.
Yes, and applying it across all charities, given the diversity of the charitable sector.
Oh, I see. So that might bring into question whether such a requirement will be applied to all or some of the charities, how often a social media check might need to be applied, how far back into the social media history one might need to go, for example. Are they the sorts of things you have in mind?
Yeah, and I think there might be some impediment. I'd have to definitely confirm this, but applying it just to a certain subsector might be problematic.
I see. Why is that?
It's just normally you don't try and make laws with respect. This is more tax laws with respect to a particular person. There's in tax there's a general prohibition against tax laws that are arbitrary and are targeted at a particular person. Tax is normally applied more broadly and generally, so people don't see tax as being used as a weapon against a particular person.
But that sort of concern wouldn't arise, for example, on a restriction by reference to the size of the charity measured, for example, by revenue?
Yes, that's the way often you can deal with issues like that.
Ms Phillips asked you about the erosion of trust that might occur if somebody who contravenes Section 18C of the Racial Discrimination Act might be permitted to be a responsible person of a charity. Would there be any impediment, and does Treasury consider it desirable, to include such a finding as a basis to disqualify a person from being a responsible person?
I think subject to the constitutional limits that we'd face, we have had regard to adding offences to, in terms of hate speech and racial vilification, into the governance standards.
So the only concern that you have is the constitutional issue?
Well, we'd want to seek further advice, yeah, but the constitutional issues is the issue I'd raise today.
I asked Ms Woodward about the possibility of subjecting requirements in respect of racial vilification offences to basic religious charities, even if they were left exempted for all other purposes. Do you have any comments about that proposal?
I don't quite recall exactly how you phrased it to Ms Woodward.
I'll put it to you fairly. It would be possible to subject basic religious charities to a standard, for example, that the responsible person of it not be somebody who's been convicted of a racial or religious vilification offence. Would that be something that Treasury would consider appropriate?
Again, I think you look at the charity sector as a whole, but if you were saying it's inappropriate for for one charity to engage in race hate, I think it's applicable to say that applies to all charities, including basic religious charities.
And the same could be true, for example, of the specification within the duty of care of a requirement that a basic religious charity take care to avoid the commission of racial vilification offences. Is that right?
That's right, and I think as Ms Woodward said, one of the governance standards already does apply to basic religious charities, governance standard 6, so we could examine whether other governance standards could as well.
Thank you. And this may be so obvious as to go without saying, but some of the difficulties that you raised in your evidence earlier about referrals of state powers and the frequency with which that might occur would be solved if state parliaments themselves were to enact a national scheme, for example, to deal with the issues about federally regulated entities. That's right, isn't it?
I'm less familiar with national schemes, but I know yes, the Corporations Act was initially done through a national scheme. It was found to have some issues that resulted in having to have a proper referral of powers, but I think it's another option.
Thank you. Thank you.
Thank you. Thank you, Mr. Brenda. Mr. Kaplan.
Just one question, Commissioner.
Yes.
Ms Brown, could you please go to paragraph 47.1 of your witness statement?
Yes.
Here you canvass potential amendments that could be made to Governance Standard 3. Do you recall Ms Phillips asked you some questions about those proposals?
Yes.
Yes.
Sorry. Yes.
And there was some focus in that questioning on the first part of paragraph 47.1, namely the reference to Governance Standard 3 being amended to prohibit a charity from engaging in an act or omission that's a summary offence related to racial vilification or hate. Do you recall that?
Yes.
Can I ask you about the latter part of 47.1, where you refer to or an act that would be unlawful offensive behaviour under the Racial Discrimination Act. Do you have in mind there an amendment to Governance Standard 3 that would prohibit a registered charity from committing a civil breach of the Racial Discrimination Act?
I think that's what we contemplated, but I would want to confirm that. Sorry. Looking at those words, we haven't actually said that, but I think that's what's contemplated.
That's what's contemplated.
Yes.
All right, thank you. No further questions,
Thank you,
Commissioner.
Mr. Kaplan. Anything arising? Thank you, Ms. Brown.
Thank you.
You are excused. Yes.
Commissioner, there has been a proposed change in the order of witnesses for this afternoon. Dr. Ali Alsamail is in the hearing room and available to give evidence now. Can I just indicate I don't expect his evidence will be, although of course significant, it won't be for the duration that was predicted in the timetable, but it's a matter for you whether we sit past one or not to finish him. But
Well,
should we start?
Well, look, I take it the evidence, even if it's not quite of the length anticipated, is not going to be completed in
It's
7 minutes.
That's right.
That being the case, it seems to me the sensible course, noting how well we're travelling today, is to take an extravagant lunch until 2 p.m. I'll adjourn.
Silence, please, all stand. Please be seated. The Royal Commission is now adjourned.
Commissioner, I call Dr. Ali Alsamail.
Yes. Will you take an oath or make an affirmation?
Affirmation.
Stand and face the Commission. Do you solemnly and sincerely declare and affirm that the evidence you shall give will be the truth, the whole truth, and nothing but the truth? Please say I do.
I do.
Yes, thank you. Do sit down.
Please state your full name.
Ali Alsamail.
Your address is known to the Royal Commission. You've produced a written statement dated 5 August 2026.
Correct.
The contents of that statement true and correct?
Yes.
Commissioner, I tender Dr. Alsamail's statement. It has the ID STAT.899.00001.0628 and its annexures.
Yes. Yes, the statement will be received as an exhibit with the annexures.
Dr. Alsamail, you're a medical doctor and an Islamic scholar.
Correct. Yes.
You are a director of the Shia Muslim Council of Australia.
Yes.
Can I just ask you some questions about your own personal background? You arrived in Australia at the age of 9.
Yes.
And where did you grow up?
I grew up in Auburn.
Yes. And you still work from Auburn.
So yeah, my I guess a lot of my religious work is based out of a mosque in Auburn, and my professional work is in a different place.
Yes. You obtained a Bachelor of Medicine from the University of Newcastle, and you practice as a GP.
Correct. Yeah.
And you also lecture at one of the universities in Sydney.
I'm a conjoint lecturer, so I teach medical students on site. Yes.
Yes. Now, you mentioned you were involved with a mosque in Auburn. That's the Al-Bayt Islamic Centre, is that right?
Correct. Yeah.
Could you describe the centre and who it's open to and what its functions are?
Sure. Yeah. So the centre's been in Auburn for, I guess, since the mid-90s in different forms, and since 2013 we've had a bit more of a larger space, and we provide regular Arabic and English programs. The English programs mainly targeted at youth. A lot of our community is quite young, and we provide sort of regular classes and lectures in English, and our vision really is to help youth to kind of receive like a contemporary, relevant understanding of Islam and Islamic teachings that nurture a sense of community and identity for them, help them to become productive members of society, and to have to be able to make choices informed by their faith. That's the vision for what the services that we provide at the mosque.
As well as your qualifications in medicine, you have bachelor's and master's degrees in Islamic studies.
Correct. Yes.
And you employ that education in the provision of religious services and teaching that you undertake at the centre. Is that right?
Correct.
Are there a particular number of students or attendees at that mosque?
So we have like what we call a madrasa, or like a weekend school, similar to like a Sunday school at church. So we have about 200 children attend there, and then we run youth programs on weeknights where we might get 100 attendees coming through a week.
And that's open to all from the Shia community in Sydney, is that right?
It's open to everyone, but yes, most of the attendees would be Shia Muslims. Yeah.
Yes. Now, can I ask about the Shia Muslim Council of Australia? It's a relatively new organisation that was registered in March 2024, is that right?
Correct.
What led to its formation?
So I guess the Shia community has not ever been able to have like an umbrella organisation that's been able to speak up for concerns that the community may have. I guess there's enough differences with Sunni Muslims that we can't be part of ANIC or similar organisations, and so we started to kind of brainstorm and then form this organisation. Currently it has 43 members, so they're mosque Islamic centres and other religious service providers around Australia who prescribe to the Shia Muslim faith.
And they are distributed around Australia, the membership of the
Yes.
of the council?
Yes, so most of the members would be from Sydney, and then there are quite a few from Melbourne, and then a handful from each of the other states and territories.
You've said in your statement, and I see that it's the first of the listed objectives in the constitution of the council, that the Shia Muslim Council aims to foster positive engagement, mutual respect and harmony between the Muslim community and the broader Australian society. Is that right?
Correct.
And it also advocates as the umbrella organisation for its 43 members that you referred to for the free exercise of the Shia Muslim faith throughout Australia?
Correct.
You've noted that the Shia Muslim Council doesn't exercise any sort of religious authority or administrative authority by way of a complaints handling process or the like over its member organisations. Is that right?
Correct.
It's a true umbrella organisation in that sense, just providing common representation and organisation. Is that the position?
Correct.
You've addressed in your statement some of the community engagement, advocacy and events that the Shia Muslim Council participates in. Could you describe some of those events just to give the Commissioner an idea of your activities?
Sure. So we've held a couple of, we held one online civic education forum, so that was based around the federal elections last year, where we educated the community on correct voting, on the electoral process, on how Parliament works, and what their vote sort of translates to, and we felt that was really important to increase civic engagement for our community, and we delivered that in English and asked our member organisations. So we deliver that directly to community members, but we also encourage member organisations to deliver that in languages that may be sort of more relevant to their community as well. We've also held a couple of legal information sessions. That when I guess new laws come about, there's a lot of anxiety in the community, and sometimes oversimplified representations of those laws in social media. So we try to kind of provide professional and kind of a bit more detailed and nuanced explanations for the community, and they've been well received. We also do other things internally within the community. So we run some parenting workshops, and we do sort of football competitions that bring youth within our own community from different cultural backgrounds together. And we also hold an annual blood drive. So Ashura, which is a significant day for Shia Muslims, or one of the most significant days in our calendar, we encourage the community and we coordinate with Lifeblood for them to sort of turn up at blood donation centres and donate blood on that day.
You also refer to some written submissions you've made to legislative review processes and the like. Does that draw on some legal expertise in the Shia Muslim community?
Yes, we have very, I would say, we sort of run on a very thin staff, or we don't really have, everyone's a volunteer, so we sort of get what help we can from within the community, and we do make submissions and try to contribute to that process.
Are there challenges that the Shia Muslim Council faces in that sort of community engagement? You mentioned it's entirely volunteer driven. Does that pose difficulties?
Yes, that's definitely our biggest challenge. So we're very young, and we run completely with volunteers at the moment. So we're very sort of limited in terms of resources, human resources, and financial resources.
a section of your statement specifically addresses what the council has done to counter hate speech, vilification and extremism. And you've referred in particular to a resource that one of your member organisations has developed, an educational program to assist individuals who may be at risk of hate crimes who have engaged in hate crimes. It's called Wisdom and Good Counsel. You've indicated the title's a reference to an excerpt from the Holy Quran. Could you explain that reference?
Sure. So there's what we call an ayah, an excerpt from the Holy Quran, which says that call to the way of your Lord with wisdom and good counsel, and use only the best of manners. And so it's a direction to Prophet Muhammad, who is the prophet that Muslims follow, where he is commanded in the book to engage with people with these three things: with wisdom, giving good advice, and only using the best of manners. So we use that as a foundation for, the member organisation who put this together uses this as a foundation for then a short program. It's got 4 modules in it, which sort of goes through issues like, being respectful of differences, using language and words and actions which are good and positive rather than harmful, and we make reference to a number of other excerpts from the Holy Quran and the Hadith, which is the words and actions of Prophet Muhammad, which explain, I guess, the true Islamic teachings on these issues, and we feel that this would hopefully help with remove any misconceptions, because we really firmly believe that Islamic teachings, correctly understood, leave no room for any kind of vilification, intimidation, hate speech, or anything like that.
And this program has been developed in particular at the Auburn Centre at the mosque, has it?
Yeah, correct.
Yeah. And could I just, you've annexed the program outline to your statement. I might just bring it up on the screen. It's smca.8.009.001.002_0011, which is the first page of the program outline. Yeah, so at page 11 of the document, _11. So the program's called Wisdom and the Beautiful Word. Is that right?
Yeah, sorry, I think maybe the title has undergone a change to Wisdom and Good Counsel. Sorry about that. Maybe an older version.
What's the current title?
Wisdom and Good Counsel, I think it is.
Wisdom and Good Counsel. And then I was just going to draw your attention to this part of this page to reflect what you've just given evidence of to the Commissioner. There's a section on the scriptural foundation of the program, and then a reference to its alignment, as you see it, with Australian values and social cohesion. Could you just address those two sections briefly?
Sure, yeah. So when we were developing this, we really, I guess, also wanted to make sure that anyone engaging in this program could see the overlap or the agreement between what the Holy Quran teaches and some of the core Australian values. So, we values like ethical communication, mutual respect, non-coercive dialogue, and the rejection of hostility, intimidation, or imposition of views on others through force or fear. All of these are, so I think the excerpt from the Holy Quran and this program, which draws from it, is really in line with those values that are part of, I guess, what we would consider to be basic Australian values.
And if we could go to the next page, please, just to pick up the 2 bullet points that you referred to, Dr. Alsamail, at the top of the page there, reflecting the Australian values as you describe them and their consistency with the scriptural foundation you referred to. Is that right?
Yes.
And you mentioned that this is delivered over 4 modules. Has the Auburn Centre had the opportunity to carry out this program on many occasions?
I mean, it's a really good thing that we have very rarely had to do it, but there is one case where we are waiting on the person to be available to to take part in the program.
Yep.
But thankfully it's very, very rare that we've had concern regarding these issues raised, like about someone within the community.
Yep. So would this be considered to be appropriate to be rolled out more generally as just an education and training module rather than a specific response to an individual of concern?
Yes, so I think we haven't yet sort of thought about how we would roll this out as a preventive measure and a wider education piece, but I think it definitely could be just tweaked a bit to be used in that way.
Thank you. And if I could go back to the text of your statement, please, just to ask you to address paragraph 21, because you have described there how the Shia Muslim Council has supported the Australian Muslim Advocacy Network's submission in respect of the dehumanisation framework. Could you just give a little context to that and how you see the Shia Muslim Council participating in that framework?
So I think we feel that if there's quite clear guidance on what is dehumanisation and or in particular this issue of dehumanisation, then that can just allow young people, particular within the community, to be able to speak more confidently on issues that they're concerned about without it moving into anything that's harmful. We believe that whatever approach is taken to the issue of hate speech should be universal, and so we would also recommend the adoption of something like the National Anti-Racism Framework that addresses all types of hate and all types of vilification. So that's the context to that. You no doubt saw that this hearing block of the Royal Commission is directed, among other things, to measures that might be undertaken for disengagement of individuals who might seem to have the potential to move towards extremist views. And your observation in the final sentence of paragraph 21 makes a point about how people might be led to feelings of marginalisation and frustration. Could you address that mechanism as you see it? Yes, I think when people feel unheard, which is something that we hear a lot from young people in our community, they feel that when they speak up, it's their opinions are not heard or reflected in the mainstream media, wider media, for example, or they're unable to express grief for what they see as human rights violations occurring in conflicts overseas. Then they can feel marginalised, frustrated. They feel like they're less than other, Australian citizens, and so we think that by giving them a voice, then that reduces the chances of that, and we've sort of outlined in the statement how we try to do that, and I think part of it is what we've talked about in terms of having a consistent framework that addresses all forms of hatred, but also some positive things that we try and do within the community, like to try and show them how they can have a voice and not feel disengaged or marginalised.
Could you elaborate a little on those techniques?
Yes, I guess the first one was some of those sort of educational pieces we did around civic engagement and legal information sessions. The other thing that we do is, like, when we do make submissions to parliamentary inquiries or we appear at parliamentary hearings, firstly we make an effort to do that, and secondly we do try to keep the community informed of that, so that then they do feel that their concerns, their opinions are being heard in Parliament, in other important institutions, and we hope that increases engagement and gives them I guess hope and positive feelings about the system, if you like. And
do interfaith programs also form a part of that? Is that another mechanism by which to achieve that sort of goal?
definitely, we really strongly believe in that. At the local level within our mosque, we have a really good relationship with a particular church in Auburn, the Auburn Anglican Church. They visit us and we visit them on a regular basis, and we try and take young people from our community to the church, and they bring their students to us for visits and get a feel for the mosque as well. We also, so that's at the mosque level, and at the level of the SMCA, I personally engage in interfaith programs. There have been 2 of particular note held in New South Wales Parliament, which have been really good because they've been roundtables of faith leaders from across almost all faiths, who've been able to talk together and answer questions based on their faith understanding in front of again quite a diverse audience as well, and so that I think is good modelling for the community. We'd love to take this to the next level where we're able to get youth together at a grassroots level, and we've had discussions with various religious leaders around that. Limitation at the moment is just resources, but that's something that we'd really like to do, and we feel that's a really good way of just overcoming that kind of effect of that online echo chamber, where you can meet someone in person and it completely changes what you thought about them from what you read online or have seen online about particular communities or cultures or faith groups.
And part of the formal mechanism for that sort of interfaith engagement includes your appointment to the New South Wales Faith Affairs Council. Could you describe the work of that council?
Yep. So the council sort of meets on a quarterly basis, and we discuss issues, I guess, relevant to faith communities, whether it's with regards to legislation, government policy, how laws are applied to faith communities, and so on. So that's one side of it. The other side of it has just been the ability to meet with faith leaders from other faiths, and that really has helped, at least for me personally, understand other, faiths' concerns and viewpoints, and has created a lot more empathy, and again broken down, I guess, some of those maybe barriers and misconceptions that can happen when we don't meet or talk to people from other faiths. So for me, it's been a very positive experience, and it's just led to us then being able to talk and have programs that run outside the formal mechanism of the council, but which then lead to interfaith meetings and things like that.
And the council is a committee of Multicultural New South Wales, is that right?
My understanding is yes, but I have to check exactly what the formal.
And have you raised in the context of the Faith Affairs Council your attempts to increase interfaith meetings at the grassroots level, so to get the youth involved from each of the different faiths also to meet and engage?
I don't think it's been raised formally in the council meeting. The meetings tend to be jam-packed with lots of agenda items, but definitely we've had some meetings with smaller groups from within, because there's about 20 members, I think, or 18 to 20 members on the council, but in smaller groups we've met and have made some informal plans to try and get that going, but unfortunately haven't quite yet done it yet, but hopefully with some help and resources we can get that done.
Thanks, Dr. Alsamail. Do you have any further questions?
Yes. Perhaps if I can just ask a couple of matters. Firstly, after the Bondi massacre, did the Shia Council take steps to express condolences to the Jewish community?
Yes, definitely. So on the same Sunday night, and then again on the Monday or the Tuesday, but in both those dates, the Shia Muslim Council issued statements condemning the terror attack and sending condolences to the Jewish community.
Can I ask you a couple of questions about the death of the Ayatollah Khamenei, who was killed in February of this year as the result of a bombing attack by the United States. As I understand it, the Ayatollah had a position of religious significance for the Shia community globally. Is that fair?
Yes.
But in addition, he was the supreme leader of a country with whom Australia had severed diplomatic relations after the IRGC was found by our intelligence agencies to have engaged in the arson of a Jewish synagogue and the arson of a Jewish business. In the period following the Ayatollah's death, it was reported that a number of Shia mosques were holding periods of mourning in relation to his death. Can you explain how we as a society, if you like, Dr. Alsamail, are to reconcile a display of mourning in those circumstances?
Thank you, Commissioner. I think the intelligence reports indicated that there were certain criminal elements that were involved in those two horrific attacks, which we completely condemn and would never. It's a horrible thing that happened to any Jewish business or any other Jewish organisation. There were criminal elements. They're not community members at all. They're not. These are not people who at our mosques or anything like that. These are professional criminals who were
Dr. Alsamail, I certainly wasn't suggesting that.
I just wanted to clarify that. So I guess if you were then to a religious authority like Ayatollah Khamenei, we would we don't know, I guess, what the line of hierarchy there was, whether there was a rogue element or something like that, but we know that at least we would believe that the Ayatollah would never have any direct involvement in anything like that at all. So I think and the mourning was for a religious leader, a leader in jurisprudence and theology, aside from any political or I guess authority positions that he held.
Just briefly, can you explain the religious significance that the Ayatollah held for for the Shia community in Australia?
So Shia Muslims believe in something called a marja. So spelt in English, it would be M-A-R-J-A. So that's a person of religious, very, very high religious education that we would refer to when it comes to jurisprudential rulings and theological knowledge. And there are very few of those who are unanimously agreed upon, and he's one of two or three that would have been alive at the time who were in that position. And so it is a very high position, almost, like some news articles kind of compare it to the Pope. It's almost like that, and there's a religious, spiritual, jurisprudential kind of authority there, and then I guess that's something that stands aside and independent of other political or other authority positions.
Yes. Look, thank you for that. Anything arising, Mr. Lancaster?
No, thank you.
Thank you very much, Dr. Alsamail.
Thank you very much, Commissioner. Thank you very much.
You are now excused.
Thank you very much.
Commissioner, can I invite you to take a brief adjournment because the next part of the hearing is closed?
Yes, indeed. I'll just adjourn briefly.
To her second statement, and just with a view to it perhaps being able to be given publicly, I very briefly rehearse just a little bit of background in more general terms, including specifically in this portion of the evidence we'll refer to ADE's young relative as opposed to ADE. You've just given some evidence to this commission about some concerns you have about a younger relative of yours who you perceive to be in the process of radicalising to adopt far-right, extremist and neo-Nazi beliefs. Is that right?
Correct.
One of the things you've done is to try and access some support for yourself and for your young relative. I'd like to ask you some questions about your process of seeking support. Can you describe to the Commission the sort of support that you thought you were looking for and that you thought would be helpful in your situation?
Sure. I was looking for support that was in person. I was looking for people with expertise in the area of far-right extremism, neo-Nazism, and radicalisation.
And as you decided to seek some support, did you have any prior awareness of a service or an organisation that you could contact?
I had seen Exit Australia was mentioned in a TV documentary that I watched. Also, the Step Together website was also mentioned in that documentary, and then I did research online. Step Together, the federal program.
So what do you understand Step Together to be?
I understand Step Together to be a website that is supposed to support with radicalisation and extremism. Although when you read more into it, it does focus on violent extremism.
And you became aware that Step Together also had a national support hotline?
Correct.
And you give evidence in your statement that you decided to ring the hotline, motivated by the concerns you had about your young relative. Can you tell the Commission what happened when you rang the hotline?
Sure. When I rang the hotline, I explained the young person's circumstances, including his increasing exposure to extremist material, the changes I observed in his beliefs and behaviour, and the factors that I believed him that made him susceptible to radicalisation. I appreciated that the service existed and that somebody was available to speak to me. However, I left that interaction feeling that my needs had not been met and that all I was being provided with was being directed to a police intervention program, which I didn't feel was appropriate as a first step to introduce the young person or his family to a police program.
And when you indicated that you weren't seeking direction to a police intervention program, what then happened in your conversation with the representative on the hotline?
This is what I called the national helpline. Pretty much, they weren't able to direct me to anything and just gave me general advice of other counselling types of services and tips which were available on the website, and I stated that I could find a general counsellor myself, and I don't think that was going to be helpful in this situation, because with young people and with this young person, I think they've had a lot of people have already had enough exposure to counsellors and other people that don't get them. And so being exposed to another person who didn't understand or didn't get them, I didn't think was going to be helpful.
What had you hoped the National Support Hotline might have been able to provide you with?
Yeah, I'd hoped to access independent specialist support from a counsellor or psychologist in our city that was not connected to a police program. Practical education materials, especially for the family, clear information about the signs and progression of radicalisation, and in particular the groups that are influencing young people in the broader community. Because that wasn't on the website at all about who actually is in the community.
And it sounds like you spent some time on the Step Together website, is that right?
Yes, I tried to.
Can you explain to the Commission your general impression of the Step Together website?
Sure. Well, firstly, no disrespect to anyone who built it. I found the website poorly designed and difficult to navigate, and I would imagine, someone who's not familiar with getting around a website or with a topic would find it a challenge. Much of the information on the website was vague or general, or you really had to kind of click many links to find it, and some of the links didn't work or went places that weren't helpful. While the available, and at the end of the day, the available support program is a police intervention program. There's little or no information about the specific groups or patterns of behaviour, including those associated with far-right extremism or neo-Nazi beliefs, which I found troubling. I also found that the website could be difficult for someone unfamiliar, as I said, with radicalisation. To help educate my young relatives, family and myself about the Australian and international groups from which he'd been obtaining information, or with which he may have been involved, I really had to independently research myself and compile lists of various resources, like news articles and videos and various documentaries. There was also something a little bit troubling with the website, that on the front page, it states something which it appears to separate radicalisation from violent extremism, stating radicalisation is only wanting drastic change in the society. It doesn't mean that person is going to be violent, that it's okay to have, radical thoughts of drastic change in society, which I do agree with, but in doing so, it really risks misrepresenting the very real social and personal harms caused by far-right radicalisation, and overlooks that spectrum between physical and non-physical violence. So it felt like, your child could be acting out in all manners of way, but if they're not blowing something up or somebody up, this website's not for you. So where do we go between something doesn't feel right? And I do want to say that when I say I don't want this young person to cause anyone harm, I'm talking verbal harm as well. I'm talking about excluding people. I'm talking about the serious harm that comes from the expression of some of these ideologies. That to me is equally as harmful as violent extremism.
One of the things you mention in your statement is that when you engaged with Step Together and spoke to the person having called the hotline, you had some uncertainties about confidentiality.
Oh, sure, yeah.
Speak to that a little bit?
Yeah, it wasn't until after the call that I went, oh gosh, that they didn't, I don't recall any confidentiality statement being read out to me. And then I was surprised a few days later, somebody called me back from the town that I live in. I recently called the hotline again just to check it out, and what came up this time was an automated recording at the beginning of the call stating that the call would be recorded. I did hang up at that point, and had I received that notification when I first called, I would have hung up as well. I believe others may respond similarly, particularly if they are concerned that information disclosed during the call could incriminate themselves or someone else. So I don't think that's helpful that you're being told, even before you speak to someone, that an automated voice is telling you this call will be recorded. So.
And your own experience, you said, is that would discourage you from proceeding with...
Absolutely, I would have hung up. Yeah, I would have hung up that first time.
Yeah. You mentioned that after you spoke to someone from the hotline, you received a follow-up call. What happened in that call?
The follow-up, the person I spoke to, the follow-up call certainly was more helpful, appeared more aware of my concerns. easier to talk to about the concerns. But really, at the end of the day, all she could offer was their police intervention program, and I stated, well, surely if you've got all these, if you have these resources within your police program, psychologists, counsellors, interventionists, then can I not access them independently in the community? But no, they weren't able to give me any community contacts at all, and kind of call back if I change my mind. So,
what are some of the reasons you have felt very reluctant to engage with a police intervention program, or the prospect of your young relative being referred for engagement with a police intervention program?
Look, that's just escalating it to a point which would not be helpful right now. I don't believe we need the police right now. I hope we don't need the police. But to suggest to a family who are just getting their head around what is actually happening and what is the significance of happening with their family member, to say, oh, your child has this issue, and hey, let's go to the police. I don't think anyone would want to do that at all. And look, for me, that's a last port of call. I hope we don't need it, but I'm glad to know it's there, and I'm glad to know it's there for others, if that's appropriate. Absolutely, I'm sure it's 100% useful. I can see they have quotes online of testimonies how helpful the program's been for people, but that certainly wouldn't be a first port of call. I don't think, to think that any family would think that's the first place you're going to go, not at all, no matter what amazing specialists they have or claim to have.
And sitting in a position where you don't feel a police-run program is appropriate, and you feel there'd be a lot of reluctance, you've already spoken a little bit, but what does it seem the alternative, if anything, is?
Well, there was no alternative offered to me, really. I mean, if you do, dig through the Step Together website, there is some information on how to have a conversation with a young person and how to talk about values, if you get that far with the website. But I know I was wanting somebody locally that we could, potentially meet with. That they could meet with in person. So that's where, I guess out of my frustration, I then reached out to Exit Australia, who I was aware of through the media and also from doing my own search online. So I just asked them the question, hey, do you know anyone in our location who you can recommend? And they got back to me, and we had an extremely helpful conversation, very empathetic and understanding conversation.
So you became aware of Exit Australia, you chose to contact them. How were you able to contact Exit?
They had an email message form on their website that I was able to email, and then pretty promptly they got back to me and said, oh, would you like to have a conversation? So yeah, we arranged a time to speak on the phone and had quite a lengthy conversation. I felt really comfortable and confident in the person I was speaking with, knew what they were talking about, and that was a great relief to be speaking with someone who knew clearly what they were talking about. When my initial question to them was, could they refer me to anyone in my area? They offered to speak to another psychologist that they worked with in another state to see if they knew anyone. They got back to Exit and said they didn't know anyone. However, the person in the other state was willing to do telehealth and willing to provide that service. Also, I want to say as well that I had asked other mental health specialists in the area that I work if they knew anyone working in this area, and they came back saying no, they knew of nobody.
So you understood Exit to be a non-government, not-for-profit organisation who specialises in this space, is that right?
Correct, yeah.
And then they put you in touch with a psychologist who you were able to do some telehealth with, even though they weren't local. To the extent you feel comfortable, can you summarise the sort of assistance the psychologist was able to provide you with in those sessions?
Sure. Really, it was around, the most valuable assistance was really around family support, how to communicate and be with family. It was around being able to manage the moral dilemma. Because I got to the point where didn't believe I could hang in there with the young relative. Like, I had other people saying to me, oh, well, you got to be mindful of your own boundaries and take care of yourself. And as a psychologist and other people, Exit and other people have shared, like best you can to stick with them. And that's bloody challenging. Like, that is really, really challenging. Like, I feel, yeah, that's really hard. So really hard.
So they helped you not only think about how you can support your relative, but they also provided support for you.
Oh, yeah, absolutely.
Difficult situation.
Oh, absolutely. And that's what... And even my intention was like, even before... in the best case scenario, the young relative would have spoken to that psychologist, but firstly, I would have, it didn't happen. Firstly, I would have liked, the young person's parents to speak to the other family members to have that conversation so that we can all get on the same page. That would have been my best case scenario. Hasn't happened, but I'm able to do the best that I can with other family members. Not all family members are coming on board, but I got great support and advice around how to be able to manage that. Yeah.
And that's obviously a situation that continues to be real and ongoing for you at the moment.
Absolutely, yes, it is, absolutely, yeah. Which is a challenge here, speaking about it, yeah.
You've given evidence about how this experience has been difficult to navigate, despite you coming to it with some relevant professional expertise and experience. Can you share with the Commission some of your concerns about other individuals who might find themselves in a situation similar to yours, and some of the difficulties you feel they're likely to encounter?
Well, I think I was able to see the warning signs, like I knew what to look out for, and I think people don't know what they don't know, and so how do family members know what's happening? I think a lot of the warning signs that Step Together talks about could be describing any young person or young adult in too much online activity and so forth. But this movement, I perceive it as to be growing. I perceive it as insidious, and that the algorithm, like the one area when we're talking about young people, particularly in view of the under 16s not having social media, it's not the social media, it's the insidiousness of the algorithms that are really targeting them, and that's what we really need to be talking about. It's targeting young people. I also want to add it's targeting adults. That it is adults as well, not just young people, but I think we need to be cognizant of that people don't know what they don't know, and how do we support others to recognise those signs? How do we support others to know that casual racism that they might joke about at home, that normalises an environment where young people can be, it validates these more extremist views, and yeah, I am concerned with what's happening in the broader community in regards to the racism as being enabled to be spoken really freely, and that supports these more extremist views.
At the conclusion of your statement, you say, in my view, there's an urgent need for accessible, specialist and preventative support for families and concerned individuals seeking to intervene to help someone they're concerned about before things escalate. Is there anything you'd like to add to that for the Commission about the real need you see and the gap you feel you've experienced when trying to access support?
Yeah, the gap in support has been very frustrating, and I could see how a lot of families wouldn't manage with it. One thing that would have liked would be access to timely specialist intervention, but also lived experience support. Like the lived experience support from Exit Australia was really helpful. Lived experience peer support really helps, and that's where someone doesn't necessarily need to have an academic profession, but some training in utilising their lived experience to support others. I think that could be very powerful in this environment, and just some meaningful alternatives to the police-led responses.
Commissioner, I didn't have any further questions for this witness.
Yes. Thank you, Madam. Your evidence is appreciated and you are excused.
Thank you.
And
Commissioner, I believe that is the conclusion of the hearing for today.
well, what a very satisfactory announcement, Ms. Hammond. I'll adjourn till 10 a.m. tomorrow morning.